Yes, solution.
One payment of salary, area salary.
Listing matters, please give it to me. You will give it.
May I please, your lordship? Item number 11 and 12. This has become infractious, lordship.
Sure.
Here.
Miss S. Kanungo, Learned Counsel appearing for the petitioner, submits on instructions that the issue as arising in the proceeding has since become infractious. Accordingly, she prays that the writ petition be dismissed as having become infractious. Also, prayer accepted. Writ petition stands dismissed as being having become infractious. Item number 11 and 12. 11 and 12, same goes to
Deeply obliged.
May I please, your lordship? In item number 10, there is no surviving cause of action. So I have informed the other side also.
I am appearing for the respondent.
Mr. A.D. Chaudhary, Mr. D. Chaudhary, Learned Counsel for the petitioner, on instructions submit that the issue as arising in the present proceedings have since become infractious. Accordingly, he prays that the writ petition may be dismissed as having become infractious. Full stop. Prayer accepted. The writ petition, prayer accepted. Full stop. The writ petition stands dismissed as having become infractious. Mr. G. N. Sahewala, Learned Senior Counsel, assisted by
H.K. Sharma, H.K. Sharma.
H.K. Sharma, assisted by Mr. H.K. Sharma, Learned Counsel, appearing for the respondents number 1 to 4 are present.
Much.
May I please, your lordship? I beg to mention item number 15, your lordship. I have informed the other side. My senior.
Wait.
Item number 50. I am appearing on behalf of D. Borua.
No, wait.
He is indisposed, your lordship. He is undergoing medical treatment. So,
Mr. Pine? Mr. Pine is there?
yes, your.
Mr. Pegu is there?
I am appearing on behalf of D. Borua.
What happened to the other two? 2014 matter.
Yes, your lordship.
We'll have it next week. On the prayer made on behalf of Mr. D. Borua, who is said to be indisposed, list this matters again on 9/5/2020.
Much of
Item number 15 day.
My
Yes.
lord, I'm praying for listing of an item for tomorrow, my lord.
What is it?
My lord, the petitioner here is the complainant of sexual harassment against her. And the ICC of Ames took up the matter, and the sexual harassment was established. The allegations brought against the accused was established. And my lord, they have submitted for the initiation of departmental proceedings against him. And my lord, the authority who is competent to take up the disciplinary proceedings, a non-competent authority, my lord, has taken up the matter in his own time.
Person. Man.
My
Who
lord,
is filing the case? The lady or the person?
the lady, my lord, the petitioner. For tomorrow, my lord. Oblige me.
May I please, your lordship? Your lordship, beg to mention one pending petition for listing, your lordship. I know.
Wait, please, your lordship. Lordship, I beg to mention a contempt for.
We have started dictating, but I am running short of my hand. These are two very new people.
My lord.
So we'll pass the orders.
Deputy Oblige.
Just vote. But subject to what we finally say,
My lord.
the proceedings have been found to be done in the manner that it is required to be done. So that coupled with the
My lord.
earlier proceedings, we don't know where. And you don't have a period of, even if we direct for compulsory time, I don't think so. With the gap periods you have, you fulfill that criteria. Let's see.
Deeply oblige.
Yes. Dispose of. We'll pass on this.
Lordship. Highly best.
Hearing the petitioners are seeking provincialization of their services. In fact, they were claiming under the act which was when declared unconstitutional way back in the year 2016, the 11 Act. And there they had made a claim there in the first round of litigation. Lordship will recall that those writ petitions were allowed. The Honorable Court, Division Bench of the Honorable Court had ruled that the scheme under the Act by which which mandated that only a particular fixed number of teachers would be taken, even though they were continuing in the service in accordance with the pupil-teacher ratio. And that was approved at that point of time, that they are entitled to be, they're entitled to be.
And your writ petition
provincialized.
claiming salary was dismissed.
After that writ petition was allowed. Thereafter, as it is the respondent authorities did not take steps to provincialize the service. And then we came for, after the new act came, 2017 act came, we made a claim for salary because the Honorable
That
Court.
was rejected.
That was rejected. Thereafter, the division bench had issued some directions and that directions were not properly carried out. That is why this instant writ petition has been filed. The impugn order, which in fact the inquiry was directed to be conducted and that inquiry has come at page 66.
So, we have it. So this has to be given some meaning now.
Uh,
66 and 67, the reports.
Yes,
So your only thing is that you will have to approach the authorities. The authorities would have now to place your case before the DSC in terms of the act. And thereafter the process be taken forward if you are found to be eligible.
Lordship, may I
Because there is a requirement here that you must also have third and fourth post. You must also have the
Third-
enrollment.
enrollment, yes. At that point of time, when we first came into litigation, challenging that act, because in terms of the enrollment, in keeping with the pupil-teacher ratio, we were allowed to, we were appointed and were allowed to continue in the services. And that has been approved by the Honorable Court in the division bench judgment.
That is
Chandra
under
Kumar.
the 2011 Act.
Yes, that has a
Now
bearing, that has a
we
bearing.
have to have, they will have to examine it.
No, that,
That examination, can you show me for each of the schools that are there, the students that are? It's not on record.
no, that why we have not, because this is the continuing litigation.
Be
At
that
that-
as it may.
That at that point of time, that was placed. And in accordance with that, the Honorable Court had approved that, allowed our writ
The
petitions.
present act requires that enrollment for the period say 17-18, 16-17, 17-18, either of these 2 years. So they will see whether you come in. And if you come in, they will consider your case, that we will direct. That much only we can do.
No, but
What do
the-
you want? What is the relief you are seeking?
of course, provincialization of our services.
From when?
It'll be a new, it'll be under the new act now,
It will be a new exercise.
a new exercise.
Because that act, under that act, you exercise consideration by the DSC, by the SLC has not been done till now.
Yes, but what about that?
That is gone. That this court has also said that is gone.
No, that observation has a bearing at that point of time.
That is with regard to 11,
Lordship,
2011 Act.
yes, 11 act.
So we can't force them to stick to that. They'll have to, there will be a new exercise
No,
altogether.
that just, the observations in that judgment, that in accordance with the pupil-teacher ratio, we were appointed in keeping with that PTR
And
ratio.
Madam, we will have to allow them to have their own independent examination. You will be at liberty to bring on record any material you want in that connection. Let them take that decision. Why should
And
we?
so far as this inquiry which they have already made pursuant to the division bench judgment.
They'll take all this into consideration, but there is a procedure prescribed under the Act. You will have to move through that procedure. DSC, SLC, and thereafter the recommendation. Therein, all these matters would be verified. You also appear, I'll do it like this. I'll ask you individually, because these cases have to be considered individually.
Yes.
This together thing we are condoning in this case. We are not, it's actually a misjoinder in this petition. We'll condone that. You individually submit representations before the Director of Secondary Education. Give therein all the datas, including the observations made in the earlier proceedings. We'll ask the director to scrutinize that. And thereafter, if you are found to be eligible and required, and there is a requirement of your cases to be considered, we'll ask them to place it before the jurisdictional DSC. And thereafter to take the matter forward, basing on the recommendations of the jurisdictional DSC. That means it will naturally come before the state level scrutiny committee. And basing on the recommendations, to take a call whether you have to be provincialized or not. If not provincialized, to communicate to you in form of a speaking order, the reasons. That much we will do.
But the.
And a time frame.
Yes, may I just make one submission? The inquiry which they made, as it is reflected in the, in page 66 of annexure 5, it indicates that,
Madam, that it is there. Let them take that into consideration.
yes, that,
Naturally,
yes.
they'll verify that.
yes.
You can't prevent them from
No,
verifying those
yes. that-
in accordance with law.
Lordship will also make, indicate the observation made in the earlier.
We'll
division
not say
bench
anything.
judgment.
We'll not say anything. We will not limit their consideration. That is for you to
No,
bring it.
not-
That is because that is under 11. I'll not bring that in.
In division bench judgments pursuant to which the.
Whatever
inquiry
it is there, we will give you liberty to bring
Yes.
all those before the notice of the director. The director will then take a call, place it before the DSC, SLC as per the requirement and thereafter. If they don't take into consideration certain considerations which are relevant, it is open, always open for you to come back.
Lordship will indicate a time period within which.
Yes, we'll do that. We'll do that. And next time, don't bring all these things together. This we will not accept. This has been given, so we are proceeding with it. Because there was a litigational history here. So we are proceeding, but next time, all the 7 people may have 7 issues. Right? So next time,
Yes.
only trouble is that you will have to have,
Otherwise, they are similarly situated.
You
That is
cannot,
what brought in.
because certain schools, there are 7 schools here. 7 or 6 schools are here.
Yes, sir.
So that we will not permit. Every school would have its own characteristics.
Yes.
Disposed of.
Obliged.
Okay, writer has been given,
Oh.
but it becomes a little longer, my lord, I could not,
No, it's
Yeah,
okay.
because
The details are better. A detailed one is better. Enough.
and in continuation of the deliberation on the earlier day, my lord, one thing, my lord, was, my lord, we are deliberating on whether they have the power to suspend. But this notification 14/8/2015, perhaps it gives the power to them.
No. It is with regard to, when I.
Page
after that
29.
matter,
Page
I just
29.
went through it once more.
29.
It says, if you can just have that enquiry, departmental proceeding, award of penal punishment,
Yes.
appeals. So this etc. will have to be read in the context of the words preceding,
Yes. My lord, that's my lord, for
because
enquiry,
suspension cannot be
for enquiry.
for enquiry.
My lord,
Enquiry means under that 9,
That's my lord.
9.
The spirit of the rules, my lord, the entire rule, it has been met,
No,
my lord, the entire rules and
Prescribed here for
procedure,
enquiry, departmental proceeding, award of punishment, appeals, etc.
etc. So
As
if
and
they-
when, an enquiry or departmental proceeding are required to be
Yes.
conducted. So it
Both.
is in the process of, in the stage of conducting that enquiry
as well as departmental procedure.
proceeding, it will come. But suspension will not.
Suspension, because my lord, the first reference is spirit of the rules, and it is in fact
It is
therefore,
qualified.
therefore, my lord, while I have joined the service after my arrest, they have passed an order saying that the files and all these things will not be allowed to him.
Because they can't suspend you.
That is in a mode of keeping me out of the service,
Maybe,
because
maybe.
no files, no.
They can't
procedure.
suspend you.
That's it.
They can't suspend you. Only thing we got to inquire, see here is whether there is a stigma attached.
Yes, yes. That's what I have already given.
Only that thing. The rival arguments are before us. And
this-
nothing more.
Second,
And last time we discussed this issue as to whether that agreement,
that's it.
which is there, which ought to have started from 1 to 112, but did not happen. This came to the surface, this allegations. Now, in that view of the matter, you having been paid from 112 till that day, your remuneration has been, whether it was fine, for the director to come to a conclusion that this man may not be conducive for us. And stopped at that stage, which they seem to have done. Let's see.
Achha. And my lord, to that aspect, my lord, if your lordship looks into the 8A once, my lord, again, rule 8A,
Hmm.
it says, my lord, continuation after successful completion. So once the earlier term is completed, then they will assess. So there will be definitely a gap, but then it will be continued. Eight A. After successful completion of the term of the agreement on deputation, so and so.
Now, this has to be read with the schedule. If I call it a schedule under 8A, serial number 42.
Lordship.
Decision on continuation of employees on deputation, attachment and further engagement by employees on contract by the MD. So the MD, it's not a automatic process.
Yes.
There has to be some
Yes, that is
application
also
of mind.
Self, but this also clarified in the the agreement. It says self-appraisal report will be given. That will be assessed by them for further continuation. And secondly, if they
You
find
had
that-
submitted your self-appraisal report.
yes,
That
and-
was before done.
yes, and
So
if-
this material that came in subsequently, if they have just taken notice of that, not based their decision on that, taken notice on that, motive, not foundation, then there will be no problem. That's what this court has to arrive at.
yes. And thirdly, my lord, the inquiry report conducted by the department, they said it is 3, but it is 4. What I see, my lord.
3 in a sense.
3-man inquiry committee, they said.
That one man here, there, what difference is?
One should not be a judge of the case, my lord. That's what I said. My lord, if this inquiry committee, this signature 4 is also part of it, my lord.
Okay. Fine.
And lastly, my lord, I just two judgment.
More judgments.
Yes, the other day I have given the others, my lord, the only 2, my lord. One is 2009 6 SCC 611. Muhammad
2009,
6 SCC 611.
name,
Muhammad Abdul Kadir versus DGP Assam. Well, in paragraph 17. Paragraph 17.
Hmm.
It is said the person engaged in contract basis in a scheme are normally continued for till the end of the scheme, unless he is terminated for the this misconduct or ill health or superannuation, etc. Otherwise, normally,
disciplinary matters are not included there.
my lord,
Disciplinary matters not included. Disciplinary matters in paragraph 17.
When the ad hoc appointment is under a scheme and is in accordance with the selection process prescribed by the scheme, there is no reason why those appointed under the scheme should not be continued as long as the scheme continues. Ad hoc appointment under the scheme are normally coterminous with the scheme, subject of course to earlier termination either on medical or disciplinary ground or for unsatisfactory service.
Anything more?
And regarding my lord, they have illegally, my lord, restrained me from discharging my duty. So my lord, in case my lord, it goes, inclines to my lord, set aside, my lord, in that case, I'll be entitled to my lord, the monetary benefit or the salary, whatever. My lord.
Whatever was due to you till your date of your continuation,
Lordship, my lord.
that much they'll have to pay you.
Lordship, my lord. No, that they have paid,
Then,
but from that onwards, my lord.
or if we interfere,
Interfere.
back wages sort of
Lordship,
concept.
lordship. There is AIR online 2022
Hmm.
SC 460, my lord.
Can you give me the name? 463
460.
0. Name?
Gowaramma, GOWRAMMA,
GOWRAMMA.
space C
Huh.
versus manager within bracket personnel Hindustan Aeronautical Limited.
How?
I'm referring to paragraph 12.
Now, the other concept, is this the only way out? If we, in the fact circumstances, come to a conclusion, okay, fine. They ought to have given you an opportunity because indirectly there is a stigma attached. Is this court only left with the option that you will have to be put back? Now, you cannot be placed under suspension, you will be working somewhere. Now, this allegation not having been proved or disproved till now, can't this court have an apprehension that putting this man back may not be in the public interest? So without putting you back, just asking them that no, for the purpose of that inquiry, we put you back, deemed, and then let them go ahead with the inquiry. And in the event they find that you are not culpable, you are not involved, then you get back everything.
Yes,
That would be equitable to both sides,
yes,
right?
yes. Or else, my lord,
If we come to a
There may
definite
be-
conclusion that this whole thing was a fuss, then Hal will come in. Why Hal? There are many other judgments. But if there remains a gray area, wherein this court cannot come to the conclusion that yes, he is to be exonerated, he is exonerated, there is nothing against him. If we go beyond the requirement, whether there is a motive and a foundation involved, even if we come to the foundation conclusion that this is the foundation, is the only way out that we will have to direct his reinstatement. We can also ask the authorities to deem that he is there and then proceed with the matter within a time frame.
obliged.
Yes. Yes, Mr. Second.
Lordship, in fact, I have already completed. my-
You have made your detailed
Yes,
argument.
but I want to see what exactly is his prayer, page 21.
Yes, Mr. Second.
So the first prayer is that 19/6/2023 order should be set aside. Or why it should not be set, that is the prayer.
Hmm.
And that later is very clear that Mohammed Giyas Ali, Finance and Accounts Officer, is hereby released from the contractual service on account on his lapse of contract agreement on 13/11/2022. So suppose this is set aside. What will happen, Lordship? So without a contract, can he continue?
That is why we were asking him.
Yes.
6O clearly mandates before 8 comes in that there has to be an agreement.
Sorry,
There has to be an agreement.
there has to be an agreement. That agreement
6O
is not there.
of your regulation.
Yes. Now, number 2 prayer, the second prayer. The respondent authority shall not be directed to allow the petitioner to continue in his service. As it is a contractual employment, Lordship, there are thousands of cases I can place. I have already placed also that no court will enter into that area to direct a contractual employee service to be continued. 3, release the withheld salary from the month of April 2023 and also to continue to pay the
This
regular
will
salary.
come in if 1 and 2 is done. If without 1 and 2 being allowed by this code, prayer number 3 cannot
No,
come in.
prayer number 3 is also vague. It's vague. Now he has said that this order was issued in the month of June. So till that day, he has received the salary.
Subsequently, after filing the petition.
Okay, fine.
No,
That will
whatever.
not go.
So this prayer has complied with. He has not said that the regular salary should be paid till date. No, the regular salary till his period of service.
Mr. Sakya,
Lordship.
in addition to the way, the order, even if we lift the veil, that impugned order, we lift the
Absolutely.
veil, we will come to the note of the director,
Yes.
MD, which was not given to you, it was given to you in
Yes,
the court
yes.
last time. So only thing we now got to see is whether that reasoning there is the foundation or a motive. If it is a motive, that is the end of the matter.
Yes.
If it is a foundation, then we will have to proceed a step further, require that he should be given an opportunity because there is a notification. In such circumstances, the spirit of the 64 rules will come in.
Yes.
So in that view of the matter, without reinstating, if we come to that conclusion, if we dismiss, that is the end of the matter. If we come that is a foundation and that requires to be looked into,
Yes.
by giving him an opportunity, because there is a stigma. Tomorrow, if somebody, he applies somewhere and there is a
Absolutely,
letter
Lordship.
given to
If
him.
that area is open,
Hmm.
if Lordship directed, we should complete an inquiry or hold an inquiry. It will go against him ultimately.
Whatever it
Yes,
is.
if that risk he wants to take, we are
Let it-
welcoming that.
I know that,
We are welcoming that.
but see, if we.
Till
if-
now,
Hmm.
it is not a dismissal, so there is no bar for
For
him
his-
to give for re-employment.
His
But
argument
if we
would be,
dismiss, it will be a recent order. That risk, whether he is going to take fine, we have to just close. And on top of that, the spirit of that particular 1964
Rule.
rules has to be followed.
Followed.
That we have already followed.
No.
We gave him a so called notice and he have responded. And Lordship, he was at the helm of affair. He is the finance and accounts officer.
see, that is why when I was interacting with him, I said, even if I come to that conclusion, that yes, you are required, this is a foundation and you are required to be given an opportunity under the 64 rules spirit of that. But we are not convinced to pass an order, at least this court, not convinced to pass an order for his reinstatement.
Yes.
Given the nature of the allegation, maybe I'm using the word allegation. Because he
that is the
cannot be
criminal
placed-
jurisprudence part.
No, he cannot be placed under suspension, contractual employee.
That
There
we
is no
have not
concept
done.
of suspension.
We have not done that.
That's it. And even if I reinstate him, I can't ask him in public interest to be allowed some
And that will
post.
send a very wrong message.
Wrong message.
Very wrong message. People
Any
will
more
do-
judgments, Mr. Swigya?
Yes, then number 3, whether he has a right under Article 311. He is not a government employee.
That we have already,
Yes.
last time we have already
So-
deliberated.
And whether this honorable court would delve into the motive part. That is also not necessary. That is also
Only
actually
motive-
not required.
Only motive and foundation, if you have any judgment to
Yes.
that extent, kindly give me.
Judgment will listen. It would be fabulous. It would be second. I found that part also. That High Court may not like to enter into the
Just give me
find
that
out the,
citation.
yes, I'll give Lordship.
Just give me the citation, that'll do. There is a latest Supreme Court judgment. I read it, but I somehow could not,
On what
Okay.
point, Lordship?
on this contractual employees part only. I think the Supreme Court held against the petitioner there. I'll have to examine.
I'll just give that judgment. The High Court may not like to enter in, delve into that area of fact-finding exercise.
Fine, Mr. Singh.
So I'll give that judgment, Lordship.
Anything more?
I have nothing more, Lordship.
Mr. Bora, whatever submissions Mr. Saikya has made, he has reduced it into writing. Can just give it point wise, just for my reference.
Then let it, I'll give it tomorrow, 10:30, Lordship.
No need. You take your time. Give it to me on today's Thursday.
Today's Monday morning,
Monday morning, you can
Yes,
just give it
yes.
to my
along with the judgments also.
judgments, whatever it is, there,
Yes,
just
Lord.
give it. We will list this matters again on 16th, and if that day we are in a position, we'll pass the orders on.
Lordship.
Hearing concluded. List this matters again on 16/5/2024 for delivery of orders.
And that objection, that written submission, I will submit.
Mr. Bora, S. Bora, assisting the learned Advocate General Assam, is at liberty to bring on record the written argument along with the case laws, list of case laws
Lordship.
relied upon by the learned AG in his deliberations.
Highly obliged.
Sometimes it looks so simple, but once you start
No.
going into it, now
Otherwise,
I'm
it is a
still
simple
learning.
matter, but Lordship has entered into it. So various legal nuances.
There are.
Yes,
There
there
are.
are.
There are. And Mr. Swigya, I must confess, I'm learning. Daily.
Till we go to Novagraha, Lordship,
Novagraha.
we will be doing that. Highly
Really?
obliged.
Mata. Yes. Oh, no. This matter I cannot take up. I was the standing counsel. List this matter again on 8/5/2024. Let it come up before, but not by me, not by me. List this matter before any other bench without me. No, they did demonal again. 12 matter, Mr. Chaudhary, do one favor.
Sure, sure.
Do one favor. On Monday, if the bench changes, make a mention. 12 matters should not be pending.
Yes.
They might not be interested also. I appeared. I think I appeared in this case. So,
Mr. Bora was there. Yes, Bora was there for the.
no. Let me see if I appeared in this case.
He was for the petitioner.
I appeared
Shiva, I am not aware.
in 2012, maybe just after my engagement as a standing counsel.
Few months back, somebody from Alipur came and handed over to me.
Just ask somebody to make a mention
Yes, yes,
Monday if the bench changes.
I'll do that.
Yes, Mr. Soma. What more confusion is there?
This is regarding the recruitment process.
I know.
where
What is
regarding
the more
allocation of
confusion you
marks,
want to add?
I am supposed to submit certain judgments to indicate that allocation of marks can be done if there is no oblique motive attached to that, and there is no hard and fast rule or thumb rule regarding that. It has to be a
And that
percentage.
this was a norm in your organization.
Yes. I'll just place some judgments.
Give me a hang of that. What is it?
Yes, I have placed 7 judgments. I have given a cover letter also with all the judgments therein. Now, the first judgment that I am placing is on the proposition that if the statutory rules does not otherwise provides, the selection committee is within its rights to frame its rules. That is just for that proposition. Then the 3 judgments. that I
Here,
have-
the selection committee did not frame. You imposed. The company framed it for the selection committee.
Yes. Ultimately, the management, basically.
Management.
The employer. Now, the other 3 judgments that I'm placing, I'll go into the judgments, but before that,
Rafiquddin, forget it.
no, Rafiquddin has some very important
9
observations.
and 12. Let me see.
Yes. Must be directly going to Rafiquddin. Yes. Now, Rafiquddin was on the proposition that qualifying marks, number 1, there was 2 propositions there. Apart from that unplaced candidates, that seniority issue, that is the main issue. But somewhere in between, there were 2 more issues that were dealt with. At paragraph number 9,
You are on the point, maybe, that the weightage that is to be given to an interview component will vary.
there were 3 arguments coming from him. Number 1, the allocation of marks for the interview could not have been as high as 25%. Number 1.
Okay.
The second argument that he raised was on the ground that giving that qualifying marks. Now, in that 50 marks for interview, 25 marks he has to secure. There is 50%. That qualifying marks could not have been there. And the third argument that he made was that even if the qualifying marks was there, having not been communicated to him regarding that qualifying marks was again an error on the part of the employer.
That
Now,
last part
Rafiquddin
is what you
means-
have to answer.
The first part is 3 judgments that I am placing. Leeladhar, then there are the State Bank judgment is there, and Jaswinder Singh. Those are 3 judgments. Now, on the other 2 parts, Rafiquddin deals with the other 2 parts. Number 1 is regarding the qualifying marks, paragraph 9, and the issue of notice that he is saying the notice was not given to him. Paragraph 12 deals with that. If I may just take your lordship to paragraph 9. Paragraph 9, the first line, first of all, learned counsel for the respondent urged that clause 2 of the proviso of rule 19 did not confer the power on the commission to fix any qualifying marks for viabose. So this was the question that was raised. Now the answer lordship will find at the next page 415. It starts with the word commission.
Commission is required.
Yes. Commission is required to judge the suitability of a candidate on the basis of sufficiently high marks obtained by a candidate in the viva voce. It has to fix some percentage of marks which in its opinion may be sufficient to assess the suitability of a candidate. In the absence of a fixed norm, there would be no uniformity in assessing the suitability of candidates in the viva voce test. The commission had therefore power to fix the norm, and in the instant case, it had fixed 35% minimum marks for viva voce test. The viva voce test is a well-recognized method of judging the suitability of a candidate for appointment to public services, and this method had almost universally been followed in making selections for appointment to public service, where selection is made on the basis of written test as well as
So,
viva voce. The
Fixing of qualifying marks, Mr. Sharma,
yes.
as such, he also can't make an
No,
argument.
I'm just
His argument is in the next layer. That fixing you made, you have not communicated.
that is paragraph 12. So for abundant caution, I'm dealing with this contention also because he did raise this issue.
This court will not go into.
Yes, but he did it, so I was just placing that. Now, paragraph 12, yes. Also got that?
This is the one.
Yes. The division bench of the High Court observed that the commission had no authority to fix any minimum marks for viva voce test. And even if it had the power, it could not have prescribed the minimum marks without giving notice to the candidate. That was the division bench observation. The bench further observed that if the commission had given notice to the candidates before the steps for holding the competitive exams were taken, the candidates may or may not have appeared at the examination. In our opinion, the High Court committed serious error in applying the principles of natural justice to a competitive examination. There is a basic difference between an examination held by a college or university or examining body to award degree to candidates appearing at the examination or competitive examination. The examining body or the authority prescribes minimum marks. If the person obtains the minimum marks as prescribed by the authority, he is declared successful and placed in a respective
Okay,
grade.
next.
The next part. A, that's what got that A part.
Got it, finish it. 12, done with.
So it therefore, paragraph 12 therefore says that natural justice, the last line, the rule of natural justice does not apply to competitive examination. So therefore, the Supreme Court had said categorically that it could have been material. Had it been a recruitment process had it been a written examination for college admissions. But if it is a matter of service, public services, then this is not required. Now, there is another judgment of our Guwahati High Court itself. That is that Zahiruddin, the last judgment, the Zahiruddin of the list. 2014, which was got that. The last judgment of that compilation of those bunch of judgments. GLR. Yes. Our High Court judgment. Now, therein at paragraph 16, between addendum F and addendum Z,
Paragraph.
paragraph 16, between addendum F and Z, it starts with the line, in my opinion. Yes. In my opinion, there is no infirmity in the procedure adopted by the respondent. It was sufficient to indicate in the advertisement that the written examination carries 75 marks. And as it was the first hurdle which the candidates had to overcome, since the physical fitness was again a qualifying test with no marks being allotted, the question of indicating marks allotted for the said test in the advertisement does not arise. Insofar as viva voce is concerned, it was decided that it would carry 50 marks. It would have been more appropriate if the allotment of marks for viva voce was indicated in the advertisement, but failure to disclose the same in the advertisement would not be fatal to the selection. So I am trying to bring home this argument that yes, it could have been appropriate. Rafiquddin says on a different tangent altogether, it says it's not required. Natural justice is not required. Our Guwahati High Court, however, says that could have been appropriate, but it cannot be regarded to be fatal. Now, these two
Not a sine qua non for the conduct of this election.
Yes.
Right.
Now, therefore, these two judgments deals with those aspects regarding fixation of the qualifying marks and having not given a notice. Now, regarding that quantum in the viva voce, the three judgments that your lordships will come to first the Leeladhar judgment, because that is the mother of all judgments. All judgments thereafter just follows Leeladhar.
Okay, do not take the trouble. Leeladhar, no trouble.
Yes.
These three judgments we have. Okay.
Now, Leeladhar is again followed in the Indian State Bank officers case
And Jaswinder's.
and Jaswinder's case. Now, all these cases categorically deals with that observation or finding that there cannot be a hard and fast rule.
It's slightly diluting Ashok Kumar Sharma to Ashok Kumar Yadav to a certain extent.
Ashok Kumar Yadav is also been discussed in detail in Jasbinder. What happened in Ashok Kumar Yadav was that the spread of marks in Viva Jose was so enlarged. In the written, the marks were between a narrow campus. Like someone got 60 and the maximum was like 70. So it was like 60, 70. In Viva, it so happened that someone got 2 and someone got around 60. But the spread was so much. The court could therefore come into the conclusion that there was some hanky-panky going on to it. The authorities were using this as an oblique, there was an oblique motive involved. So based on that, Ashok Kumar Yadav said that it could not have been.
Here, no motives
30%.
have been otherwise alleged.
Yes. Now, therefore, my argument here will be the selection committee is not in dock. He has not alleged any malafide against any of the members, or for that matter, against the corporate or against this company itself. Apart from that, other issue.
He can't allege institutional bias.
I understand. But yes, sometimes it so happens that they never wanted to give it to him. He could not name a person, but then he can say that the organization never wanted to give it to him. Be that as it may.
That institutional bias is not available.
Yes. The other aspect that he was trying to harp upon was that the procedure was never placed before him. That's the procedure. But then he has not challenged that. Now, another angle to it would be that I know it doesn't fit that much, but then yes, having known while he sat in the examination that this was the process adopted, he waited. He waited for the results. In fact, his paragraph 8 and paragraph 9 says
That much leeway we'll have to give. That argument of Madan Lal
yes, Madan Lal to some extent.
may not be fitted. It's not a thing
doesn't-
that will fit in all such
It
selections.
doesn't squarely apply in his case. That I admit.
Sadananda Haloi has slightly diluted that.
Yes.
And there is something you did not know. Thereafter, that police case which
Yes,
went up to
yes,
the
yes.
Supreme. My Lord Justice Gogoi's judgment.
My argument is based on his paragraph 8 and paragraph 9. In paragraph 8, he says that he fared exceedingly well in the interview and he was waiting for the results. Then he came to know from some friends that he was not selected.
You have last date, we have seen that. Para
Yes.
8 and 9.
So therefore, my argument is that you knew when the interview was taken place that these were the norms, these were the procedures, but you kept silent. You waited for the results. Once it was against you, then you started your procedure challenging it. So therefore,
Now, leaving the technicalities aside, the only thing we got to see is whether that procedure that was followed in the selection caused any prejudice to him.
it was
That's the
universally
only-
applied.
That was the only thing
Yes.
that has to be applied.
The same yardstick was adopted for all the candidates.
It is leaving aside all these judgments, these principles of law. Factually, if we go and examine
Yes.
that prescription of marks, whether that was done only for this selection after the advertisement was issued or the game had begun, this was done,
Yes.
or this was already there, applied as per your statement in the affidavit.
Yes.
Around 500, 600 recruits were
Yes.
already done. This was already the norm. Only thing, after the interview process was, after the advertisement was issued, you were required to constitute a selection committee, and that time you just communicated something which was already there but not created after the advertisement. It was applied.
Selection committee adopted the guidelines.
It's not the selection committee adopting the guideline.
If you'll
It is
also
you
come-
asking the selection committee
Yes.
to follow this guideline.
I'll just come to that. And these guidelines were otherwise there before the written examination.
That
also
is,
took
that is
place.
what I'm trying to
Yes.
say, that these were
If your
there
lordship will
already
come-
applicable.
If your lordship will come to our affidavit, that running page 90.
90,
90.
90.
Annexure 2, internal page 18.
90.
I think 9, why?
Huh.
Annexure 2, internal page 18.
Uh-huh.
It starts with strictly confidential, 17th of May, 2010.
So, Mr. Sharma,
Yes, lordship.
this is something there already, say, it's there in the rules. You have applied,
Yes.
but it's a norm. Because this has to be understood with page 86, your statement. Para 26. It is further mentioned that the company has been following the same procedure in selecting all so and so into the company. It's further submitted that around 500 candidates have already been selected through this procedure during the last 5 years. So and so, so and so, so and so, so and so, so and so.
We
So
stand by this.
this is a norm which is already there.
We stand by this. Yes.
And it's not that you have made this, you have applied this. It's there in your, what do you call that? It may be a norm which you have created for dispose
Right.
by the company,
Yes.
and you have applied it through 17/5/2020 when 2010 as a guideline to the selection committee.
Selection. Yes, Lord. And we stand.
Mr. Manan, nothing more. This is the, you have already placed.
I have already placed that decision. I think your lordship is, I have also given the paragraphs.
Ah.
I think that will suffice to what I am,
No, I got it.
because the next
Jammu
other
Kashmir.
part he has already argued.
Or you.
This will be my
Yes,
answer.
Mr. Counsel. Anything more?
Lordship, the judgment, Leeladhar judgment was quoted by the learned respondent. In the Leeladhar judgment, it has been specifically mentioned the importance of interview.
Mr. The law now that is has evolved. The Supreme Court is not very much concerned with the percentage of marks. There has to be a justification. The question that would arise in your case finally would be as to whether they could have adopted this procedure after the advertisement was done. Now, para 26 in their written statement, they say that this is the norm we already have in the company. So it's a case of application of that norm. So it's not a new thing which was brought into. So the prejudice, as in Imani or in other cases wherein a decision was taken to introduce that for the first time. But here in the company, this is the norm applied. So whether a prejudice can be said to have been caused to you on account of that changing of the rules of the game after the game has begun. Here, the game has begun with this thing behind their mind. It is already there in the books of the, and see, Mr. Counsel, there were thousands maybe who have participated. Nobody was having any grievance with regard to application of that norm. So we'll have to also give that a weightage. Do one thing. Whatever you have, just in 2 pages, along with the judgment, just give me a note. Mr. Sharma, Mr. Manan, you need not. You this, because this is, it's only a consequence. And we have already said,
Yes,
even if we go in his favor, we will not disturb you.
lordship has already given
We
you.
will
my-
not disturb you. We will find a way out. Give me a small note.
I'll do that.
Huh? Along with this, judgments don't reiterate, just indicate. That will do.
Just
You have
I
already
did
given me
that.
copies. I don't want to be burdened again.
Yes.
When can you give me? Tomorrow? If Monday, I don't know where those bench would be, I don't know. If those bench is not there, you can just give it to Mr. or to my PS.
Yes, Lordship.
What number 26? My PS. You
On
can give
Monday,
it
Lordship.
Monday,
Yes, yes.
right? I'm keeping it on 16. On that day, if possible, we'll pass the orders, right?
16th.
The parties at length. Hearing concluded, list on 16/5/2024 for delivery of orders. The parties are at liberty to bring on record their respective arguments in a written form, along with the case laws they would like to rely upon. Copies that you have given, don't read, please give it to me again. I already have it. So I've marked it. Copies, so and so, by. 6/5/2024. Apuni thakile apni loi lobo nohole because of DPA. If he is there, you can give it to him.
I'll provide you.
Or madam is there, you can give it to
Yes,
madam.
yes,
Or to
we'll take care of that. Oblige, Lordship.
Obliged.
Obliged.
Date of answer there.
May I please, Lordship? Kindly adjourn for a day. My senior is out session. He will be back.
no, he is not back as of yet. Oh,
By this evening, he will be back.
he is coming back. When is he holding the party?
Very soon.
Already.
It is submitted there.
Already, yes, sent. Already sent. So it's in my home house.
Huh?
So it's to me, lordship.
Or through WhatsApp. On the prayer of Mr. A prayer made on behalf of Mr. R. Mojumdar, who is stated to be out of station, list those matters again on 14/5/2024.
Lordship, when it speaks, lordship.
14/5.
14.
Any
Lordship,
problem?
available here 14.
I don't know.
Then also after 16, after
After 16,
16.
20th, 21st,
21st.
21st.
Apologies.
Yes, you have got something.
Yes, Lordship. In fact, the apprehension that we had, that last time I was not very sure of what was happening. Yes, 12% was what the employer was supposed to pay. Otherwise, in the EPF, Employees Provident Fund. After the introduction of the EPS pension scheme, 8.33 of that 12% cuts and goes to the EPS, and 3.67 will go to the Employees Provident Fund. Now, what happened in this case?
What about your contribution?
12%.
12% of your contribution?
Yes.
Okay.
Otherwise, in Provident Fund, 12% of the employee
12% of the employer.
of the employer is deposited in the fund, Provident Fund.
PF fund.
PF Fund.
Now
Employees Provident
EPS has
Fund,
come.
1952.
EPS has come.
1995, EPSS is brought in to bring in this pension aspect, because earlier it was only a fund. They were getting a consolidated amount. Now they thought, let us have a monthly pension scheme. So 95, this scheme came in. Now, how was the employer's share to be adjusted? So what was done is, of that 12%, 8.33
12% of employers.
yes, we are with the employer aspect only. 12% of that employer is now divided into two portions.
3.66 PF,
3.67
PF.
Provident Fund, the earlier scheme.
8.33.
8.33 now goes to the pension scheme.
So what happened here?
Yes. Now the scheme was introduced in 1995. There were court cases. There was stay, Otis Elevator. Finally, in the year 2003, November, the Supreme Court gave a clarity that this scheme is here to stay. The scheme is a good scheme, it will be there. Now, in that particular period, these companies, where there was a stay order against this scheme, how were they giving this money? Now, my instructions from other companies also, because I tried to delve into that aspect, what they did at that point of time was 8.33, they kept it in some account. Because this EPS scheme was stayed, there was a possibility that it might come up. So 8.33, they kept somewhere. Once the scheme again came back, they adjusted the money. Here in our particular case, what happened was, we continued paying this 12% to the EPF. And this person retired in 2002.
He took that money.
He took that money, and after 10 years, he raises a claim before the pension scheme by saying that I should be also a member of this scheme because I was a member of the pension.
Was my doubt that.
Exactly. Your lordship's doubt is correct.
Yes, Mr. Roy.
And I have two documents to indicate 1999.
That don't. Anyway, maths of this course is very bad. That Mr. Roy can look into. Mr. Roy.
So what
if
happens
that
now?
8.33 is already deposited in the employee's PF fund.
It is a exempted trust, but it is their fund. It is not in our fund.
Be that as it may, that 8.3,
I'm not.
Mr. Roy, just something troubling me. That 8.33 is not to be paid twice. It's only to be paid once. In terms of the 95 scheme, 8.33 plus 3.67 is the total contribution. 3.67 will go to the PF fund. 8.33 will go to the
pension
fund. Now, prior to 95, this whole 12% was going to the PF fund.
It's not so. From where they say?
That is what I want you to give that he will give you. Now you clarify that.
No,
clarify that, Mr.
My lord, if it goes to the PF fund, we are not concerned. Because the money for pension.
Here, no, you're not concerned. That is a different thing altogether.
No, my lord.
You're not concerned. I know.
Same organization.
But the person who is making this claim will have to remit that amount.
That's their business, my lord. We are concerned with the payment of the money because under the act, they must deposit.
That act was in, they will have to. They will have to deposit.
They will have
that
to.
That money
because,
has to be given.
My lord, what happens under the act provides that whether you collect it from the employee or not, you will have to make deposit first.
Here, the
then you can make recovery.
Mr. Roy, you are before this court or the company is before this court because the employee has raised a claim from the pension fund. Now, he raises a claim from the pension fund.
My lord, let him file an affidavit or show from the record that they have made deposit of the entire 12%.
Mr. A. Sharma, counsel appearing for the petitioner, has submitted before this court that the 12% contribution as required to be made by the company in the PF account as well as in the EPS account. Mr. A. Sharma, learned counsel for the petitioner, submits that during the period from 1995 till the date of retirement of the employee, what is his name?
PC Bhattacharjee.
Pranab Chandra Bhattacharya.
PC Bhattacharjee, till the date of retirement of the employee PC Bhattacharjee, comma, on account of the fact that there was a stay order in operation with regard to the implementation of the EPS scheme, comma, the amount include in the employer's contribution, that is, if employer's contribution, including the contribution that ought to have been deposited in the EPS scheme, were being continuously deposited by the company in the PF account of the petitioner, and at the time of his superannuation, the petitioner had
Of the office.
had received the amount as so deposited along with the interest accruing thereon. So it is the contention of Mr. Sharma that in the event the EPS account has, in the event deposit is in the EPS account, comma, the petition, the person concerned, that is Mr. PC Bhattacharjee, the employee concerned, that is Mr. PC Bhattacharjee, has to refund the amount at the rate of 8.33 of the employer's percent of the employer's contribution made and deposited in the PF account to the company so as to take the matter forward. The said amount not having been so deposited, the company cannot now be burdened to make a further payment of 8.33 for the period, 8.33% for the period in question. Full stop. Mr. P.K. Roy, learned standing counsel, PF, EPF. What is the organization? PF. EPFO. Disputes the set position. Disputes the set position. Full stop. Mr. Sharma shall, within the course of the day today, place before Mr. P.K. Roy, furnished to Mr. S.K. Bhattacharjee, learned counsel assisting Mr. P.K. Roy, the concerned document which would indicate the deposit of the set 8.33% of the employer's share in the PF account of the employee concerned. Mr. P.K. Roy shall have his instructions. Mr. S.K. Chakraborty shall have his instructions in the matter. Let and place the same before this court on the next date of listing. List this matter again on when? We'll try on 16th. 16/5.
Yes.
My lord, just for a while, the lordship will take up my affidavit at page 26. They said 12%, how? My lord, they said already paid 58. The percentage they have calculated balance amount is to be paid. It is their own statement.
That's why I said
Yeah, that-
he's having some doubt. Because my only concern is,
My lord,
if this 8.33 is deposited, until and unless he does not refund it, there would be a double contribution from the company. I want to negate that situation.
my lord, 8.33 is to be deposited by them.
That's
Yes,
true.
look,
From
and
that
I don't
12%, from that 12%,
Yes.
Yes,
Mr. Roy, the whole contribution is 12%
12% for the PF.
plus 8.33.
No.
Within
No.
that 12, 3.67 plus
3.33.
8.33.
That's
Right?
the 3 point to the PF. I mean, that is their own
Our
account.
ceiling is 12%.
Ceiling 12%, breakup is 3.67 plus 8.33,
Correct.
right? 3.67 to PF, 8.33 to EPS,
Our account.
your account. Now, because of the circumstance that developed, stay orders, this, that, EPS in
There is no
this,
stay order, my lord.
be that
there
as
is
it may, no employee in that organization was enrolled under the EPS scheme during that period. 95 to so and so.
Correct.
And this amount, 8.33, was retained by the company in their pocket. One situation. Then we will have to ask them to vomit that
There, like
with
that.
interest. Another situation that this 8.33 was given to the employee's PF
No,
fund.
it's not so. It's not the case.
No, Mister, if that be the case, then
Then
they are not at liability. There is no liability attached to them. The employee has to return that amount.
my lord, that's a different aspect, my lord, because
The
liability.
employee is no longer with
We-
them.
My lord, we cannot hold the employee liable.
Mr. Roy, the employee goes away, taking that 8.33 also with him. Now, if they are to make that deposit, how will they recover it from the employee concerned?
No, that's because the provision of the act says if they default for certain period, they'll have to pay interest.
Fine, but if they have not defaulted, 8.33 regularly deposited in the account of the, that is what I want you to look.
All right, my lord, let it be.
Let it be seen.
I thought it.
Then they should return me the 8.33 that I deposited wrongly in the PF account.
No, this
12% I was
is, no, 8.33, their account. They are exempted.
Mister, we are not concerned with that, whether they gave it to you or, we are concerned whether the employee enjoyed that 8.33.
He did.
If the employee has enjoyed that 8.33 with his PF fund, I think he cannot make any further
I think,
demand.
my lord, it would have been better, he would have filed an affidavit and say this, my lord.
You take it,
But
that is,
anyway, along with the order, my lord, I can, along with the lordship's order.
this order you just send it.
Lordship.
Because, mister, just tell me, even if they have deposited that 8.33 with the employee and the employee is not there, today, can I direct them? You make a further deposit of 8.33?
My lord, employees, how they can deposit in employee's account, my lord? The amount
Because-
cannot be.
Okay, before 95, where was this 8.33 going?
8.33, their own account. Not
Account means that PF account?
PF account, PF
PF
account.
account?
Yes.
Maybe they are in, it is a trust created by them.
Yes,
Okay. But this 12% before 95 was going into that PF account of the employee concerned,
Yes.
maintained by the trust. So after 95, if that 12% was being so deposited, the man retires in 2002. 2003, they revive. They gave it, they recovered it.
I
from-
understand, my lord. Because if the 12 plus 12 is, they already got it and the employee has taken away everything, then he will have to make return.
That's all. That's all. That's all. If that position is clear,
Now,
we only will
now,
direct.
now what will remain, that the adjustment has to be made from that amount. He will have to get pension for his life.
That is true. That employee who has enjoyed that amount
That's like,
has to refund that to you, and with the calculable interest, whatever it is, he'll give it to you through him or directly to you, wherever he does it, and then he will enjoy the pension.
I understand, my lord. But my lord, the scheme is not that. On the day of retirement, he will have to pay pension.
Right? But on the
It is
date
not
when he went,
pension payment subject, is not subject to refund and everything.
Mister, I'm not on that. If the amount has already been taken, not from the right hand, from the left hand by the employee,
My lord,
but 10 years afterwards, can he come and say,
I understand, my lord. The amount goes to the fund, not fund, not to
unfortunately,
individual fund.
unfortunately, show me from 95 to 2003, when this amount was not being deposited with you, naturally,
It is not required to be with us.
that fund,
That fund is their own fund.
but you are
You are
monitoring
there-
that, you are monitoring that, you have to monitor that,
No.
you have nothing to
My
do.
lord, what I
Payment came
submit,
from them.
it is, no.
The claim
it's-
was
my
made
lord,
to us. The
my
payment
lord,
came
it's
from them.
different. Let me explain, my lord. There are PF fund which we maintain throughout the country.
Hmm.
There are certain establishments who are exempted. They
This
pay
is an
for-
exempted exam.
exempted, they have their own fund and they
This
manage
pension
this
fund would be created in their own organization,
They will maintain it. We
right,
will not.
Mr. Sharma?
Then why this letter from them to us directing us
For
to
the,
make the
for the
deposit to them?
PF, for
Deposit,
the,
why then, why
That
were
is
you
why I came
asking
and
that
it's on a
deposit?
challenge.
for the pension we are maintaining,
That's it,
Yes,
Ah,
pension.
That's
not PF.
that's it. I got it.
Pension,
PF is with them,
PF with,
pension is with you.
yes, that's,
95 to 2003 pension fund, no money was deposited. What steps did you take?
we are not taking after the Supreme Court's order.
That's all. They were also waiting for the Supreme Court order. In the meantime, the employee enjoys everything. Can be
No, my lord.
given two benefits.
Even during the period, we have written to every establishment
Okay, fine.
to maintain.
Now the employee has taken that amount with him.
No, I understand, Lord.
Only on that this is not the case wherein they have kept the money in their
No,
pocket.
yes.
They have not deposited, now they are not doing. That would have been a different thing altogether. But here, the employee, that 8.33, that quantum, he has already taken. That is why they were asking the employee, kindly make that deposit. He did not. He said, my interest part recover from my
Taking he gave that.
areas. But that amount, 23,000 or
24.
something, should have come from the employee.
Let me check
Go through
check up, let me check up.
We'll take it on 16th.
This is the reason that we came on an appeal before this honorable court. The amount is otherwise less, but then
Don't be euphoric. This is a doubt which this court had. I want a clarification on that.
I understand.
Mr. Roy shows me that even if that deposit made in the PF fund of 8.33, still you are liable.
Yes.
I'll go against you.
There-
Because my
there-
interest is the employee.
there is a particular
There is a
provision for
provision.
return by the employee.
Okay.
Section
okay.
17(2).
Okay, that after Mr. Roy comes up.
Yes, the member has to return the withdrawal benefit.
You are
There is
getting a
section.
leeway only because of the fact that you have demonstrated, at least in your petition, that this amount was deposited 12%. No part was retained by you. You
Exactly.
gave it to the employee.
Exactly.
Now, only on that extent, we are asking
And,
Mr. Roy
and,
to have.
and the conduct of the employee having
That-
enjoyed the
that-
PF, waiting for 10 years and then asking under the pension scheme.
Boy, today, if we pass this order, holding what you said to be correct,
Yes.
the employee will have to give an interest till today for that
The
amount.
employee is otherwise a party in the proceeding. I don't know whether he's
He
represented.
has not come. He's not come. Okay,
Obliged, Your Lordship.
16.5.
Yes, sir.
You give it to him today itself.
Now only I'm giving it. Dada.
Lordship, the matter may be taken up on some other day. There is some difficulties on part.
Huh?
There are some difficulty on part of us today, my lord.
Who is appealing?
My senior is on legs in another court and the other senior colleagues are also on legs.
Who are you?
For the PhD department, he's challenging a dismissal.
He's a work charge employee,
My lord,
He's a
work as
work
employee and the
not
employee
not regularized.
not recognized. He has passed away, my lord. His
Children,
I was on medical leave, my lord, then I had submitted documents and all.
photocopies were given. Originals were never brought on.
I have submitted originals also,
On the prayer made on behalf of Mr. M.K. Chaudhary, right?
my lord.
Senior advocate. And prayer is made on behalf of Mr. M.K. Chaudhary, senior advocate, for the adjournment of the matter today. Also, the said prayer is not objected to by Mr. D. Gugui, learned standing counsel, PhD. Also, list this matter again on 14/5/2024.
Published.
published.
Yes. Hmm.
Well, second round of late petition, my lord. Lordship may take up item 14.
Item number
14. Identical in this, my lord.
writ petition number
Written of 5701 of 2014.
570. Okay.
Petitioner, he was competed for the post of field assistant in the Directorate of Economics and Statistics, Assam, my lord. Initially, there is an advertisement of 18 posts. And subsequently, it was some of it earlier advertisement total.
There was an earlier round of litigation before this court.
My lord,
What happened therein?
in that.
Page 44.
Yes, my lord.
There were other writ petitions also.
There are 5 writ petitions, my lord. And 2 of, out of 5, we are in the second round. my lord.
Hmm.
Lordship may take up that, judgment starts from 44.
Now, we got it. Okay, matter remanded back. What
Yes,
is
sir.
the speaking order now? Page
Now this speaking order is
55.
page 55. my lord. It is addressed to the petitioner, my lord, with reference to the applicant petition that is so and so. It is informed that as per common judgment and order passed by the Honorable Guwahati High Court that is so and so. A team of officers of the directorate have been engaged to conduct joint re-examination of the answer script written examination of 4 petitioners, including you. During joint examination of your answer script, the marks secured by you has been decreased to 75 out of 100 from earlier evaluated 79.5.
In the earlier writ petition, you said that my marks from 20s were reduced to 15 in the earlier writ petition.
No, that in the written test, it was 80 to 79.5. And in the writ petition, in the affidavit filed by the respondent number 2, the director, he has stated that he secured 80 marks in the written state, written examination.
Okay, fine. Then what happened? 104.
In the
Comes to
impugn order, it has been stated as 79.5, my lord. The grammatical mistakes so and so. As regarding total marks awarded to you in oral interview, it is to inform you that on verification of original records of oral interview marks awarded to you by the selection board member was 23 and the same has been reduced from 24.5 as alleged. Now in the judgment, earlier judgment, that paragraph 8 onward, court will find the record of the selection process was called for by successive order and to be precise by order 12.
Where are you reading?
Page 51. Of the judgment. Paragraph 7. By successive order and to be precise by order dated 12/6/2014, 15/7/2014, and 5/8/2014, the Director of Economics and Statistics responsible was directed to produce the answer script of the petitioner. However, there is no protection of the same. Mr. Talukdar, London State Council submits that he has not.
Okay, show me that finding here with regard to your marks.
Yes,
with regard to the present petitioner.
Yes,
where is it? His number is 6413.
my lord. In the paragraph 10, my lord.
Paragraph
10. If you go by the above calculation in reference to the cut-off marks for selection and appointment, the petitioner is in WPC number 6413 of 2010, this present petitioner, and named the Jyotirmoy Chaudhary, and the petitioner involved in WPC 6414, the item number 13 million. Namely, Osim Burman would make it to be final stage of appointment. Therefore, above aspect of the matter will have to consider in reference to the stand of the respondent in their counter affidavit regarding reduction of mark. In paragraph 5 of the counter affidavit, while admitted in the original marks secured by the said petitioners, it has been stated that the answer script of the candidates securing 70 marks and above has been re-examined on sample basis. It has also been stated by that to avoid any allegation of bias approach, all the answer script of securing 70 marks and above had been re-examined. Upon such re-examination and depending upon the methodology in the answers and questions, spelling mistakes, mistaken totaling, etc., in some of the answer script, that marks secured by the candidates have been reduced. However,
you come to para 13. Which one?
However, there is nothing to indicate that any decision was taken by the selection board to adopt such.
There is also no reason why the answer scripts of only those candidates who secured 70 had been taken up for evaluation. Why not the other answer scripts? As regards the plea of the petitioner that services of some of the officials of so-and-so and utilizing so-and-so, the counterpart does not specifically deny the same. However, as submitted by so-and-so, the evaluation done by so-and-so. By the adoption of the reasons known to him, this court is not in a position to come to a definite conclusion in the matter. Right? Definite
Yes,
conclusion.
Yes,
However, as such non definitely lead to drawing an adverse inference. This matter will have to be considered in reference to the definite stand of the petitioners that 3 of the candidates did not qualify, but they called forward. Thereafter, they got selection and now come to 13.
Yes.
All the
All the above aspect of the matter
would require a fresh
consideration
consideration
of
in the
case of the
connection
petitioner.
exercise.
In the connection, Mr. Bhuyan, learned counsel for the petitioner has referred to the particular exercise that was carried out in respect of the candidate. in the decision so and so. He has been appointed now, my lord. Person to which he was found and selected and eventually he had to be appointed.
Re-examine the case of the petitioner in reference to the available material and consistently with the observation made above and thereafter to pass appropriate direction, let the exercise be continued so and so. Okay, now,
In
what is
paragraph
your-
11, my
what-
lord, that coordinate bench had held that, however, nothing to indicate that the decision was taken by the board, my lord, to re-evaluation.
be that as it may,
Yes, my lord.
after noticing that, the court did not interfere with the selections made.
Yes, my lord.
It remanded back to me
My lord,
and then asked them to make a thorough examination.
my lord,
They made a thorough examination. Now, this examination is of 10 years back.
lordship.
75, 79.5 was reduced to 75.
Initially, in the affidavit, they have stated that I got.
Fine, whatever it is, we'll have to go by, have you alleged nullified against this man,
My lord.
Director of Economics,
Yes, sir.
Statistics, in the
Yes,
petition?
sir.
Is by name here? Made party by name?
No,
Then,
director is the party.
so in that, what is the stand in the affidavit?
Affidavit filed by the director, my lord.
Where is your mark sheets? You have not brought that on record. No, no RTI is made for getting the mark sheets.
No, they have, my lord, admitted that I got 80 marks.
But
and the
that this
record is
court-
there, my lord.
But unfortunately, this court did not stop there.
Yes, my lord.
That admission was not accepted. It said that it requires a reconsideration. So they reconsidered the matter.
And by order dated 22/7/2019, they have stated that the record is with them, my lord.
You check record. Where is the record? Mr. Goswami, you have the records with you? What is this? Where is his mark sheet? Answer script.
Lordship will take note of that whether there is a decision of the board. Primarily, we are challenging that there is no decision of the board, and it is in contravention of the Rule 17 of the Assam Economics and Statistics Service Rule. They cannot do without the recommendation of the board. And they have
No,
admitted,
Mr. I'm not going to that aspect because this court did not go into that aspect after noticing it.
my lord.
So why should I go into it now? This court, in the earlier round of litigation, after noticing that your submission did not find a record of finding to that.
In any case, that record is there, my lord.
We'll see.
Yes, ma'am. But there is any decision of the board and how my marks were secured.
Lordship, there are 4 records.
I only want his mark sheet, that's all.
Lordship, but Lordship, today, after a long time, Lordship, I received this records, Lordship. Lordship, kindly accommodate 1 day time, Lordship. I will,
Mr. J.K. Goswami, learned counsel, appearing for learned additional advocate general.
additional senior.
Additional advocate general, Assam.
Additional senior government.
Senior government advocate, Assam, submits that the records of the matter of the selection process involved in the present proceeding was handed over to him today morning.
Lordship.
He prays that he be given a week's time to peruse this, list this matter again on 9/5.
9 and 10, I have some difficulty.
When? 9 and 10.
Any
List this
other-
matter again on 14/5.
14.
Lordship, can it be on 16, Lordship?
16, no
1
problem.
6.
16/5.
16.
My lord, item 16 will be taken on Monday, my lord. This
Wait.
week. My lord, actually, I don't think I have to reconstruct that brief, my lord. That is old penny. That's why I have seen the record.
Yes, Mr. Shaw, what is your grievance? That you were brought from clerk to rifle,
No, that was not. Thereafter, I was
No, no.
discharged.
clerk to rifleman.
Milord.
You were a clerk,
Yes, yes, clerk.
then converted to rifleman,
Yes.
sent for training.
Yes,
Training, you were going ahead. Last moment, some medical examination, you were out. That's all.
yes.
And you went to some hospital in Delhi and you have obtained a report. What is the stand in the affidavit?
Milord, basis is that is that
As per medical board.
medical board has.
Medical board has.
Now,
Medical,
where is that order converting you to from clerk to rifle?
Yes, Milord.
Or is it a fresh recruitment?
No, not fresh recruitment. At page Milord 29.
Okay, you were recruited as a clerk.
Clerk.
You were sent for training, but
Yes.
therein you could not achieve the standard that is required.
Test
So it is not a case that you were serving earlier as a clerk
No,
and
no.
then as a grace, they converted you to general duty constable,
Yes,
right?
yes,
And thereafter, you underwent the training.
yes,
While undergoing training, they came to this conclusion 10 years back
yes.
that you were having this problem. What is the error?
Milord,
What is the error? How can we say that this is not the problem?
before discharging me, I have been given an opportunity.
Why not it? They found medically not fit. Show me where is the law that they should give you a notice and then proceed. Show me the law. Show me the law, Mr. Swami.
That Milord, on Monday.
No, today.
Monday, Milord.
Today. Dispute. Have you filed a reply here?
Not Milord.
Huh? No. Then
was examined by that mallet specially. for
and you will not get the benefit of the Disabilities Act because Disabilities Act is not applied there.
Not applied, yes.
Then
Get
what
it.
is that? Give it a quietus.
Milord, because later on, Milord, I have went there, Delhi, one hospital, and they have said like this, Milord. So I may be allowed to give a
No, no.
representation
No,
to
no, no.
reconsider my case,
No,
Milord.
no, not at this stage. Not at this stage. There are orders of this court also.
But before discharging me, Milord, one opportunity be given to me, Milord. Because of Article 14, Milord.
Show me that is.
On Monday,
No,
Milord.
no, today. Why? Today
On
the
Monday.
matter is that if you want, I can have it at 2 o'clock. That much I'll do.
Milord,
2
on
o'clock.
Monday, Milord.
No, today, 2 o'clock. 14 matter will not.
Even
You are
tomorrow,
sick, you are not in a position to come to court, that would have been a different issue altogether. But if you are here, argue it.
tomorrow, Milord.
No, today. Ms. Gan, 2 o'clock. If you want, you can have the file, just go through it. Find out something.
May I please your lordship? Lordship.
Yes.
Yes, this case has some factual background, lordship. What has happened, lordship?
The other cases don't have a factual background.
Yes, it is there, lordship. What has happened, lordship? The petitioner, he was working as a rifleman, lordship, at Assam Rifles, Manipur. Now, Lordship, on 3/4/2013, while he was performing his night duty at 2 a.m., Lordship, he went to the he went to his quarter, Lordship. But by mistakenly, what he has done, Lordship, he knocked on the door of another quarter of his colleague, one Mr. S.C. Das. His wife opened the
Show
door.
me your discharge order. Voluntary retirement,
My lord,
which you say that it was on the basis of some documents, blank paper signed by you.
Yes, that was
Prove it, prove it, prove it, prove it.
yes.
So
Uh,
discharge order is where?
page 11.
11.
Page 11.
Where is that endorsement that you have been sent out on?
Page 12 is the relevant portion. Page 12.
At his own request. When was this given?
This was issued on 1/10/2013.
1/10/2013. So immediately you saw this,
Yes,
you got it on 1/10.
1/10.
When was the application filed?
18/11.
Why?
Uh,
Why not on 1/10 itself?
1/10, Lordship. Actually, Lordship, he
This
was.
is an afterthought.
My lord.
Two possible views. Afterthought or you were ignorant. Both go against you.
No, he was under, Lordship.
You come to your page 15.
Page
Let us
15.
read that.
Yes, may I read it, Lordship? Yes. I number so and so X rifleman GD Sunil Kumar Rabha of 30 Assam Rifle have the honor to inform you that I was enrolled into Assam Rifles on 15 May 2009. After completion of successful basic training, I have been posted to 30 Battalion Assam Rifle during my service period. I always served my duty faithfully. That, sir, I came on leave during September-October 2012. In the prevailing situation in Garo Hills at present, I was compelled to bring my family to my unit without prior permission of higher authority. That, sir, this is blunder mistake as a soldier, young soldier, Mr. Major S.M. Bhutia and my CO, Colonel Vetpal Yadav gave me heavy punishment in which I had to admitted into Assam Rifles Nodal Hospital, Mantripukuri. Discharge slip dated 16/4/2013 is enclosed herewith. Thereafter, they compel me to sign the discharge application and send me discharge from service. Honorable Sir, this is the best award of faithful Jawan. I am very much young. My other source of income now to maintain my family. Day by day, my physical mental condition deteriorating. In view of the above, I request you, sir, kindly allow me to join re-service under your command and thus oblige.
So you submitted an application for proceeding on voluntary retirement. Now, considering that in the light of page 15, that submission itself was under coercion.
Yes.
So you got this immediately?
Yes.
1/10?
1/10.
Why did you not immediately make a representation? Why did you wait till a month and 18 days?
Lordship, actually,
Where is the explanation? That 1 month, 18 days explanation is not there.
Yes, Lordship.
If you can show me, I might have missed out. If you can show me that explanation, we'll examine that.
Lordship, that explanation is not there, but these facts that he was in the hospital for 11 days.
Hospital in April.
April.
Not in October.
Yes.
Leave October 2012, not October 2013. Now tell me, Mr. Sharma.
Yes, Lordship.
In this situation, how can this court come to a definite conclusion that what you are saying is correct?
Lordship, what they have replied, Lordship, their contention is that I did not submit my application for withdrawing my resignation within 3 months. So if that be so, Lordship, I have submitted well within.
Rather, it's the other way around. Rather, it's an other way around, and I don't find a statement to that effect in your pleading. Come to page 16.
May I read it, Lordship?
Notwithstanding above, you have also rendered certificate that at a later stage, I shall not change my mind for withdrawal, cancellation of discharge. Copy attached. Copy is not before us.
Yes.
But be that as it may, you had all this material on 110 with you, which according to you was not out of your own free will.
Lordship.
What prevented you? Now show me some material to establish this.
Actually, Lordship, he is just a class 10 pass.
That plea will not. that plea we will.
And lordship, the documents, it is my pleadings in the writ petition, lordship, the blank papers were taken from him on the point blank, lordship, on gun, by placing the gun, lordship.
Why did you not file an FIR or bring it to the notice of the higher authorities?
Higher authority.
Because you have not argued or you have not contented in the writ petition that you were kept in confinement till 1/10/2013. You were not. There was a court of inquiry held.
No.
Yes, come to page, show you. Affidavit.
Yes.
Board of Officers, sorry.
Board.
Serial number, page 2, internal page 2.
Page 2, lordship.
1, 2, 3, 4, 5, 6 lines from bottom.
Yes, this was lordship never given to me, lordship. These board proceedings was never given to me. The undertaking was also obtained behind my back. Undertaking I did not sign, lordship, and contents were also not shown to me. Board
Okay,
proceedings.
show me your statement to that effect in the writ petition.
In my affidavit in reply, it is.
No. In your writ petition.
Lordship, actually, when I was sick, lordship, when I was in the hospital for 11 days, that I have stated, they have obtained many papers, blank papers, my sign they have.
I'm not on that.
Yes.
That you were not, that a board of officers was convened and you were not there. Or that the procedure that is to be followed after an application is submitted was not followed. Is there a context?
Regarding the board of proceedings, I came to know only when I received the affidavit.
Okay, you don't know.
Affidavit.
Show me a statement in the writ petition.
Yes.
Wherein you say that the application that was submitted by me was not so submitted by me. And on 1/10, when I received it, I objected. Just show me that line.
Regarding 110, lordship, that statement is not there. But lordship, those documents that they have obtained
That will create a doubt. Because on 1/10, when you received it, you moved away. You left the place. On 18/11, you come back. What happened in between?
Lordship, actually, the entire factual situation was such that, lordship, his wife was pregnant at that point of time. And he was on leave for 2 spells. After returning from leave, lordship, he received this discharge certificate and he was taken aback, lordship.
Show me that statement in the writ petition.
Yes, lordship.
That you were on leave, you came back and you were served with it.
Leave, lordship, will find at page 13.
No. Statement. Statement.
In my affidavit in reply, it is there.
I'll not go into affidavit reply. I want the facts in the writ petition.
Lordship, it is for all these reasons, lordship, records were.
Okay, prepare on this grounds. Show me. Because your facts, there is nothing to substantiate. So you will have to develop a chain to convince this group that this is what exactly happened. And you can do it through your pleadings. So examine your pleadings to that extent, then go to their affidavit. Then we will come to a conclusion. Otherwise, when?
Lordship, maybe on 9th, lordship.
Leave that week, the week next. Let it be on 16th. Or let it be on
Maybe
21st. On the prayer of Mr. G. Sharma, counsel preparing for the petitioner. Not objected to by Mr.
B. Sharma.
B. Sharma. Got it.
Yes.
CGC. List this matters again on 21/5/2024.
Okay.
Mr. Sharma,
Nice.
put in that extra.
Yes.
Otherwise,
Yes.
110, you move away. And that paragraph, there is a statement in your writ petition somewhere that you were in hospital till May. And thereafter, they had kept you in close confine.
Close one.
And on the day prior to your proceeding on discharge, the commanding officer called you and said that go to some Ved Kumar, and collect your discharge certificate. You said on that day you came to know on 110 that you were discharged. But thereafter, there is nothing in the pleading that from 110 to 1811, what did you do? They have denied that. Work contract. I'm only giving you this opportunity because the man, even if today it will be around 35, 36 years. So he has a long career.
Yes,
So work out, something can be done. Yes.
Lordship, I have to address only one thing regarding applicability of the arbitration clause. To the, in the retirement date, there is no arbitration clause. So whether
I think we have forgotten this. We'll have to rehear this matter now.
we hear the matter. Lordship, besides their Lordship, there was an agreement, a partnership agreement.
With this strength, I can't. Not a partnered matter.
No,
not kept it
not
partnered.
part. Lordship, hard a beat, Lordship. Lordship, hard a beat, Lordship.
But yes. No, I have read it. There is no problem. I've read
Lordship,
it.
let it be an another date, Lordship.
Today, but I'm not in a position. Also. As agreed to by the planning council for the parties, list this matters again on 28/5/2024.
Obliged. I'm highly obliged.
If I'm there, I'll hear it. If
My
not, you will have to make it before some other.
Yeah, please, Lordship.
Yes. Yes, Mr. Tell me, what is that?
Lordship, that general meeting was held on 8/11
8/11.
and his daughter took admission on 9/11, Lordship.
But he says
Yes.
that he has brought on record that information. It is saying 1/11.
No, it's 9. I have given the register.
Register that day I did not point out.
Yes.
But yesterday when I was thinking over the matter,
Yes.
you just check that register, that one has been converted into 9. Just check. It is here.
It is there. I have flag marked it, Lordship.
You just check that 9.
It's 9. 8.
Just check that 9. You get my point?
Yes, yes.
I forgot to point out. Yesterday when I was thinking,
Yes.
that thing stuck me. Kindly have a clarification because give him a copy of this.
Yes.
The learned counsel for the petitioner has placed before this court. What is this?
My lord, that is online copy, my lord.
The downloaded copy of the particulars of his daughters, who is a student in the school in question, and therein it has been denoted that the admission of the daughter of the petitioner in the present class was so affected on 1/11/2023. However, the documents as produced by Mr. SMT Sisti reflects that the said admission was so affected on 9/11/2023. The District Elementary Education Officer, Barpeta,
Yes.
is now required to reconcile the date of admission as given in the online copy, as well as and that so indicated in the hard copy of the admission registered as produced before this court.
Yes.
The learned counsel for the petitioner shall furnish to Mr. SMT Sisti during the course of the day a copy of the downloaded information pertaining to the daughter's education in the school in question.
My lord.
List this matters again after 3 weeks.
Yes, sir.
3 weeks.
Yes.
Also, I'll not say that, you indicate if there is some manipulation made, please take steps.
I will definitely.
List this matter after 3 weeks on a date to be fixed by the registry. Because that one you see, it's
Yes.
been made
Then
available to the naked eye.
I
Who has made it? We don't know. So maybe somebody in this school.
In the school itself. Yes.
But Mr. Counsel,
Hello.
just to become a president, you have brought your daughter from another school. and put it.
That is also a matter.
That we will not accept.
That
This
is,
let us find out.
that was not.
But this court, if it comes, you're not going to get any relief. Guaranteed. I only want to reconcile. You have no right. Why should you play with the daughter's life
That was not
to
my
further
intention, actually.
MDM interest?
And that was not my she was regularly absent from the school also,
Ah.
except for few days. No, madam. That was not my
Mr.
intention.
Counsel, we have one case, we caught him,
Madam.
but thinking of the daughter's future, we let her go. That was a lady.
Yes.
Remember?
And actually, my lord, I am a graduate, my lord, and I am a.
No, I'm not on
daughter
that.
Also, my lord.
A lady,
That area-
a
area.
lady to become the president
My lord.
had hacked the site of the school and got her name, daughter's name there included. And then when not done, they came up before this court. Somehow there was some
But-
doubt.
That is why.
Mr. Sisti got the instructions.
But among my lord, 4 miles.
On that day, I was about to impose. Then I thought if I do,
And
it
but-
may affect
My lord,
the,
I was selected. my
the
lord.
daughter.
That is the question, my lord. I was selected, my lord. Oh, my lord.
You seem to be very influential, but very influential person.
My lord.
What do you do?
My lord, I am a my lord, a social worker.
Social worker. Okay, fine. We require people like you. Why only in the school? Do somewhere else. School, any attraction? MDM. You know what is MDM? You don't know what is MDM?
My lord,
Check
my
up.
lord, I know, my
Check
lord.
up what is MDM.
My lord, but.
If that is the attraction,
And that is
then
only
find-
my lord. No, but-
find out some
not for
other
that
avenue.
Purpose, my lord. Because, my,
Then why are you fighting? You are not
Because-
going to gain anything here.
because my lord, I.
You are a
was
social
selected-
worker, mister.
My lord,
You are a social worker.
my lord.
Why do you require a designation? You can otherwise also work.
That is true, my lord. But
Then, if that is true, we will provide for that. We'll appreciate your work and we'll dismiss your petition. Do you want me to do that? Think over it. Next day.
obliged.
Mr. Chisti, please take personal interest. Mr. Deka, Mr. Pine, has the director finally concluded? Has he taken a decision in the matter finally?
Yes, my lord.
Director,
That decision is under challenge.
for
Madam.
where is that? Just show me.
That is
I'm not-
under challenge.
Let's just show me. Because what I found is the director had sent the matter for examination by some committee of the Dibrugarh University.
No, that is, my lord.
Where is the decision of the? of the director?
177, my lord, is
Huh?
fine. One page, 177, my lord.
Okay. Now, Mr. Deka,
My lord.
you are for Deepika Boro.
Yes, madam.
Now, the issue here is whether the papers that he had submitted
Yes.
were entitled to be marked. I don't know how to examine that.
Yes, madam. Yes, yes. madam.
You may know.
Great. Yes.
This was referred by the directorate to the Dibrugarh University. I found it somewhere where I.
Yes, in
found
the
it.
reply.
I just.
It is in my IM.
Yeah, okay. Now, the Dibrugarh University comes up with a conclusion, the committee there, that he is entitled to marks there. So he gets 4 marks. If that be the situation, what would be the scope of this court to now enter into the
My lord,
specialized matter?
yes. As per the order passed in the earlier petition, my lord, director was directed to consider a matter on the basis of 2 notifications, my lord. One, my lord, where the guidelines have been laid down for appointment of the assistant professors. And the second one was, my lord, whether the private respondent can apply for the post after being appointed in a similar post, my lord, within a period of 3 years, my lord. If lordship produces this impugn order, my lord, lordship will find nowhere that those were.
Show me the earlier order.
My lord. My lord, page 176 is the direction, lord.
No, the 176.
Yes.
Yes.
It is the direction, my lord.
Second, on receipt or representation, may I read now? The Director of Higher Education Assam shall hear the petitioner in person as well as the respondent number 3, Principal, Silapathar College, Silapathar, and respondent number 4, Dr. Brojan Sharma. And thereafter pass the final order for appointment of Assistant Professor in Department of Assamese, unreserved in Silapathar College, Silapathar, by taking into consideration the Office Memorandum dated 8/12/2018, as well as the Office Memorandum dated 25/6/2016 in a period of 4 weeks from the date of receipt of the representation. Till the representative disposed of and the final order is passed, the interim order passed in this case shall continue. Now, Lordship reduces the impugn order. There, Lordship will find the entire calculation was done by the OSD to the director, my lord. Direction was to the director, not to the OSD. And my lord will find at page, the last paragraph, page 177. The marks allotted, nowhere it is stated, my lord, that they can give marks in this manner, my lord. And OSD was not directed to calculate the marks. It was direction was a director.
And Mr. Pang, you are representing the college.
College authority.
Okay, Mr. Decker, we will consider this challenge. But their plea is that in absence of a teacher, the students are suffering. What do we do in that, sir?
My lord, on the earlier occasion, this honorable court was pleased to direct them. If he has not joined, then they can file an application before lordship seeking leave. But the college authority still that has not filed any such application.
No, they have filed an
There's no interim order, my lord.
Huh?
There is no interim order as on that staying this impugn order. My lord, kindly come to the order, my lord. Passed by your
That is your objection in the in your
Yes,
objection
my
you have
lord.
taken that.
Yes,
But I think there is something. Meanwhile, if the respondent is not appointed to the post, the same shall not be done till the next date fixed without leave of this court.
yes, my lord.
So we are granting them leave. We are converting this interlocutory
there has to be
application to a
specific
leave
there-
application.
This application has been filed under Article 226(3), my lord.
Fine, we will not
But there
vacate
is
it.
no interim order, my lord. They can move it.
There is an interim order, mister, that if not appointed, don't appoint without leave of the court.
Can you paragraph 8 at page 25?
8, 9.
Matter be listed after returnable date on which the prayer for interim order will be considered.
Meanwhile, if the respondent number 4 is not appointed to the post of assistant professor, Silapatra College,
My lord.
the same shall not be done till the next date fixed without leave of the court. So how can they, in terms with, after this order, proceed to make the appointment? They will not be in a position.
Therefore, my lord, in my humble submission, my lord, they are at liberty to file an application before lordship.
We will
seeking leave.
convert this interlocutory application into an application
But
seeking.
my lord, from this application, my lord, it doesn't reveal that they want to fill up that post.
They have step.
Yes, my lord, but
You can come to page 19, para 16. Where have you said that? You have said, I read somewhere.
Para 16, my lord. The applicant begs to submit its college authority.
Showed as suffering a lot for the interim order so-and-so and the submission here and above clears that the petitioner so-and-so, 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 so both together. So to that extent, maybe let him go. That will be subject to outcome of this case. He takes a,
and my lord, for a moment, my lord.
but
the rule-
again, tomorrow, given the materials here, we interfere. Right? He will lose this, he will lose other
Yes,
one
my lord.
also. So better thing, we are taking up the whole matter for hearing. When?
Yes, my
Tell me.
short date, my lord. Yes,
You want to,
and
we'll treat your
I
as the
reply, my lord.
And a department might think, I learned, might think.
Department, what to do? It's a college only.
But the impugnal, I
Department
think,
has
for the director-
given what they have to given in
Yes,
the
the court
impugnal.
date may kindly be fixed. my-
When you want it, tell me, give me a date. Also, in view, we are not disposing of the IA, we are keeping it.
28th of May, my lord.
Okay, fine. In view of the issue as arising in the present interlocutory application, comma, it has been agreed by the learned counsel for the parties that this court may be pleased to take up the writ petition being WPC number 4605 of 2023 for disposal. So accordingly, prayer accepted. Accordingly, list this IA along with WPC number 4605 of 2023 on,
28, my lord, 28.
let it be on 21st,
My lord.
21/5/2024 for admission. An endeavor would be made to dispose of the writ petition on that day. Any respondent desirous of bringing on record their stand may do so by way of filing an affidavit on or before 20/5/2024. Only on that point, I'm not interfering. Otherwise, I was under the impression, because tomorrow if we interfere,
Yes,
he loses two jobs.
two jobs. my
And
lord.
he is not before us.
And my lord, we have taken steps.
Oh,
twice
has he
on-
come before us?
Yes, yes.
You are there?
I'm there.
Oh,
Oh, yes, he's there.
so you want to take that risk? I'll modify the order. I'll modify the order, but there is
Then-
some material of Mr. Decca which would require a consideration. Iman?
I am deeply obliged.
Mr. Brahman,
My
on the
lord.
other day we fixed some matters.
Yes.
When it is fixed, it's the
Which
same,
one?
same issue.
Which one? Development.
No. There was a series before me.
Oh,
Somehow
that
it was
one.
not taken up.
No. 21.
21. We'll have this
No,
together.
my lord. It's a
This is different.
It's different, my
Eh,
lord. What I am
it
saying
is-
is, my lord.
I didn't find it.
It
different,
is
that's
a
why.
very simple case, my lord. I have applied for,
Kindly have a look at the prayer made in the writ petition, page 20.
sir. Even- yeah, record.
Yes, we need to approve. The main grievance is that, my lord, the affiliation has not been received from us too. Or should we see the prayer,
Now tell me one thing.
my lord?
Is ASTU approved as an affiliating organization by PCA?
We are not required to take any approval, Your Lordship. While the approval was granted by the Pharmacy Council to the concerned college, who will be the examining authority that was written in the.
Are you an examining authority
Yes.
under the provisions of the
Yes,
PCA?
yes, Lordship, we were, Your Lordship, but as of now, Your Lordship, this state government has withdrawn that affiliation power from us, and it was.
How can the state government withdraw that? We are an autonomous body.
A university is
university.
otherwise an autonomous body, but the affiliation part, Your Lordship, state government issued a notification, it says that from certain date, Your Lordship, it will be the.
With the enactment of the.
Sankar
Sankar.
University.
Now, your university ASTU is also an act of the legislature.
Lordship.
Was that act amended to that extent or repealed to that extent by the Sankar Dev?
My lord.
No,
It
it
is
was
the
an
point.
administrative order, the executive order, Your
Huh?
Lordship. There is no, it was an executive order, Your
How
Lordship.
can Mr.
That, Your
that
Lordship.
ASTU, it's under an act. Now, if you want to restrict, how can you do it with an
My
executive
lord,
order?
for that, my lord, that act of the ASTU, my lord, it should be placed for the honorable board, my lord. At least whether they can do that, my lord.
Last date you were supposed to, I think you gave me the Sankar Dev.
Yes, my lord.
I-
But, my lord, one thing may I point out, my lord, in the present writ petition, the policy of the government, which has now been, my lord, notified in 2023, that, my lord, is the Sankardev University will be the affiliating university for, my lord, pharmacy education. That has been not put to challenge, my lord, in the
If
present proceeding.
ASTU, here we are not concerned with what the state government is saying. We are concerned with the
Yes,
Pharmacy Council of
Yes.
India. Pharmacy Council of India has approved ASTU as one of the examining bodies.
no, not, my lord, as one of the examining authority, my lord, in the case of the present petitioner, when they applied.
No, they can't do it if they are not under 21, I suppose, under the Pharmacy Act regulation 21 or something. The examining body has to be Pharmacy Act.
Yes, my lord, it's 12.
12.
It is the fellow applicant who is to propose that they are applying for affiliation from this particular
No,
university.
before that, there is a requirement. Maybe I'm wrong, let me just.
12-2.
Yes. Any authority in a state which holds an examination in pharmacy may apply to the central council for approval of the examination. And the central council, if satisfied, after such, if that approval is not there,
Not there, my lord.
how can you?
We have not applied for your specific instruction is there, but your lordship, while granting approval to the.
They
concerned
cannot, that
college-
is in violation
Yes,
of
yes.
12-2. Yes, Mr.
Yes, ma'am.
Buragoi.
Yes.
If they don't have an affiliation, the examination is not approved under 12-2, mere referring to that university as the affiliating university,
My lord.
would that give you any? Who is appearing for PCI? Yes, what is your instruction on this?
My lord, here,
Why did you, where is that?
They have
That
their, my lord,
prescription?
the affidavit.
Where is that prescription, Mr. Gogoi? Where is that prescription, Mr. Buragoi?
My lord.
That prescription, that ASTU would be the affiliating body by PCA? I mean, the permission granted to you by PCA.
Yes.
Mr. Gogoi, where is that prescription made that ASTU would be the affiliating body?
Yes, sir. Sir, I have given one comparison of the rule. It is 4th of June 2007.
There are two in my writ petition, my lord. There are two, my lord. I have page 6.
No, in this.
Yes. A College of Pharmacy, Dental and so. Controller of examining authority hospital. Controller Assam Center, so and so.
Lots you will see the act of the, my lord, university, my lord, Sankata University, there is picture.
That question is also there. Is Sankadev University approved as a under 12-2?
Yes.
Sure.
That's what, my lord,
Sure.
otherwise, my lord, may I place this kind of document, one bunch, my lord, that I, here it has been shown.
See, and if that anything here has to be under the Pharmacy Act, you
Well-
can't have an independent. thing.
Yes, I understand, my lord, that's why I'm saying, my lord. The lots you will see this bunch, my lord, that they have furnished.
And her pharmacy education is a part.
Yes.
Then ASTU has it. They can provide courses, provided they have the infrastructure, but they can.
Well, page
Now to
32.
take this out, Shankardev will have to have. Yes, Mr. Bhattacharya, what is the position of law?
lordship, so far as your lordship ASTU is concerned, your lordship, till your lordship issuance of that particular notification by the government, your lordship, we have been granting affiliation, your lordship, subject to the fulfillment of condition laid down by the UGC, your lordship. And since
Central government.
we did
It's
not
just-
grant them affiliation on the ground that your lordship NOC from the state government was not there, your lordship. That's the only reason why.
Now, are you still interested to give affiliation if this court directs?
That affidavit will be necessary, my lord. That
We, your lordship, as per our instruction, your lordship, we are interested in, since your lordship. we
Okay,
earned
if you are
some resources-
interested, show me
Lordship.
that under 12C or 12, that provision, you have been approved as an examining authority by the, then
We have not, your lordship. We
the
have not
learned
applied for
standing
it,
council,
your
learned council, CGC, Mr. B. Sharma, learned CGC shall receive instructions from the Pharmacy Council of India as to why in the permission as granted to the petitioner institution to open The
page 32, my lord.
page 32.
32. This is there, my lord.
Huh. 32.
Yes, my lord. Granted
page
approval for
Why-
19.
As to why, while granting approval to the petitioner institution to start pharmacy courses, comma, the examining authority was denoted as the Assam Science and Technology University, Guwahati, when it is the specific stand of Mr. S. Bhottakur appearing on behalf of the university that the university has not been approved under the provisions of section 12(2) of the Pharmacy Act 1948 to act as an examining authority in the matter.
They have not applied, Your Lordship.
Not
We have applied. We have applied, we are showing your lordship the document.
They said instructions shall be procured by Mr. B. Sharma, CGC, in writing from the competent authority of PCI and placed before this court on the next date of listing. List this matter again on 28/2/2024.
In the meantime, the ASTU files an affidavit, stating that they also want to. give-
It is also, Mr. Bhottakur is at liberty to bring on record an affidavit filed by the authorities of ASTU, ASTU, right? Stating that they are interested to provide affiliation to institutions offering pharmacy courses, and that for the purpose, they are also willing to take all requisite steps in the matter. They said affidavit also be filed before the next day. We'll resolve it. Mr.
My lord, only one prayer, your lordship. My lord, the pharmacy examination may be held last part of this month or the first week. And without getting that affiliation, my lord, this
Can't help
106.
it. Can't help it now.
That will be
Everything
difficulty for
is
us.
in-
Any
Because if I have to
ordered-
go into the question of affiliation, Mr. Bhottakur and Mr. Gogoi would say NOC. And NOC is pending in that series. That is why I said, when have we fixed those matters? 21st.
23. 20%. Let it be on 20%.
We'll fix it on 21st. On that day, if I'm here, I'll handle. If not, you make accordingly. Prayers. List this matter again on 21/5/20. Try to get your answer.
A copy of the order, my lord.
Download it. We'll upload it.
Right.
Mr. You can take this. But without an examining body, how can PCI say that that will be the examining body? They have not even approved that body under 12(2). And you keep your Shankardev examining that order ready. If the other matters come to me, I'll catch you on that.
My lord, both are well or equal.
Ah,
What university or any other university. Only saying that I have taken your power, that cannot be. They will have
but
to.
it's state legislation.
Yes, my lord. They can amend it, then there will be no problem.
Repeal it.
Repeal it.
Whatever they do, they do.
Oblige, my lord.
Yes, Mr.
No, on the last occasion, my learned senior friend has graciously admitted, my lord, that it was due to some animosity or bitterness, I would call it, my lord. That is why the impugn action by the guide, my lord. In any case, just to refresh your memory once, my lord, lordship may kindly peruse 37, my lord. Everything would be cleared. Page 37 of the.
Oh, that PhD.
Yes, my lord. The guide and the research column, my lord.
Go
Page
to
30.
them. Now, what relief can I give you?
My lord, in my humble submission, my lord, if legally speaking, my lord, the impugn order, look, I'll just narrate the, my lord.
No, tell me what I can do for you.
My lord, in fact, what has been challenged is an order which is issued on the behest of a committee formed by the guide herself, my lord. That is pursuant to the executive
Your
council.
case is my case for that thesis was already done by the
Yes,
executive
yes.
committee and everybody had approved.
Yes,
But your guru, because of the
yes.
maybe Guru Dakshina given in a wrong manner, she has gone against you.
Yes. Now, what had happened, my lord?
And the last date, I think, why did we adjourn this?
Because my lord, the learned counsel appearing for
On behalf of.
University of North-
You were supposed to have. Yes, what do you say, mister?
They
Look at
actually
them, they are
have not
warning.
objected.
They are at loggerheads, let them be.
Loggerheads.
They have not
But you are
objected.
the one who has to resolve it. Tell me what to
My
do.
lord, my affidavit is clear, my lord.
Hmm.
Executive council allowed to hold a viva voce.
Huh. That
And
that
this
will hold
page
the field.
37 is also clear, my lord.
Huh.
It is as per discussion
Exactly.
in the executive council.
That's what I'm
It
saying.
is the highest executive body.
So now thereafter, why was it not taken forward? That's my query. Why was it not that decision of the executive council? Why was it not implemented?
My lord, in the meantime, my lord, the entire matter has become sub judice before.
No,
this
no,
honorable.
no.
So.
Sub judice
in
was
this
after
order-
you denied her. When
No, my lord, the
on the
executive council
advice
has
of
not-
Mr. Roman, it happened.
My lord, in fact,
my lord,
oh,
I
sorry.
don't know the background.
I
my lord.
think what he has done to his guru, he has suffered.
Already.
Much suffered. Now you take a stand. You get the interviews done.
In fact, my lord, the viva voce expert was also called for
Called
from a different state.
Now
There
We
some-
have already taken a stand. So, my lord, we don't have any
you will
objection
stick
take
to your
any-
stand.
My lord,
That's stand. Mister, we'll allow them to go. Any problem?
No, I have no problem because it is the university authority
Huh.
who can declare, because my duty is limited. Because I didn't.
We will overturn everything saying that the Mr. Pukan has said, I have taken a stand. I mean, the executive committee has
Council.
taken a stand
Yes, sir.
that he should be
allowed the.
allowed the viva voce.
Yes.
Now we will say what has happened. Copy paste that paragraph if required and then direct them to do it expeditiously. We'll ask the registrar to fix a date in terms of that. And if they have to take any steps prior to that, they will take.
That technically university can do.
I think what she
Because-
did to you,
because only-
what she did to you,
No, only.
no, what she did to you,
No.
if
what
you
I-
harm a guru, you will have it.
No,
Karma.
because she has not carried out this order till today, because Lordship kindly turn to repetition page 40.
40.
That is repetition page 40. It is academic register's letter addressed to Rumi Akhuria.
Right. In fact, I should have recused from this case since the respondent number 6 is also my guru. So, my lord,
And that
my lord,
last paragraph. Yes. However, from the contents of the email of the supervisor, it appears that you did not visit the laboratory at all in considered as a major failure on the part. So till today, she has not carried out.
So when is the EC's,
My lord, compare that with page 37 for a moment. Kindly, my lord, page 37. And
no,
also
when is that EC's decision?
13, 12, 21. That's the, I'm referring to that only, my lord, page 37. If my lord kindly produces it once, it will be clear, my lord. In fact, the guide's approval is no longer required because the highest academic body, which is the DRC has also admitted, they have also said that the thesis is all right and she should be, she is eligible to appear for the viva voce. I'll just read it out, page 37 for a moment. Kindly, my lord, page 37. With reference to the subject and your letter as cited above, this is to state, but this letter is addressed to the guide, my lords, to state that the matter of MS Runmi Atporia, research scholar of the Department of Physics under your guidance, was placed in a meeting of the Research Council held on such and such date. The meeting resolved to entrust the head of the Department of Physics, GU, to hold viva voce examination of the scholar. Also, this was
Is the
placed.
DRC's report here on record here?
It's not on record, but it states, my lord, the last line, the subsequent decision of the DRC and the Department of Physics held on 7/1/21 is also there. It's, DRC, as per the guidelines, my lord, is the highest academic body.
So
which grants
DRC
PhD.
rendered some opinion.
Yes, they said it's all right. but
Okay,
it's
we'll
a party.
keep it for, we'll allow her, we'll keep it. But before that, just to satisfy Mr. Roman, we'll ask Mr. Pukan to place a copy of that DRC's decision. Okay? Parties heard at length list this matter again on 16/5/2024 for delivery of orders. Mr. PJ Pukan, on the honor before the next day, shall furnish to this court a copy of the decision arrived at by the Departmental Research Committee, finding mentioned in the communication dated 13/12/2021 of the Academic Register, Guwahati University, available at Annexure H to the writ petition. Mr. Fukan,
My lord, it's a meeting of research council. my lord.
Research Council, last line.
Third line.
Last line of DRC.
Departmental Research Committee,
Yes.
because that decision was in terms of two things, complaint and subsequent decision of so and so.
DRC.
So the head of the department physics was directed to hold the interview. Just for our satisfaction, you'll get it, you just get it.
In fact, DRC is a party, my lord, respondent number 5.
Mr.
Just one, my lord, on the next, one difficulty may arise. I'm just pointing it out today, my lord. Because as per the rules, when a research scholar goes for Viva Voce, there's an external examiner and there's the guide. Now, there's the provision is also there. If the guide is not available, the registrar or the vice chancellor.
We will ask the authorities
Yes,
in
yes.
view of the animosity to take steps accordingly.
Yes.
That we will do.
I'm
Just
very
point it out.
I'm very grateful, my lord.
Point it out.
Yes.
Mr. If I'm not here, also you just, if possible before that, either to him, her, or my private secretary. Just give that copy. If I'm not here also, I can deliver that on.
I'm deeply obliged, my lord.
And Mr. Monto,
Sir,
just give me a small note.
Yes,
So that,
yes.
that point is highlighted. Please take into account their submissions also.
Like a list of date, my lord?
Not a list of dates. A small paragraph of your argument.
Today itself, my lord.
No, not today. Give it to me tomorrow.
My lord.
Just take into account, bring in their statements. And that last submission that you made.
Grounds taken in the AIO and the petition and
Petition and this, and the
summarize
last
it.
statement that you made now.
My lord.
With reference to that rule, wherever it is.
Yes.
Just quote that.
I'll quote the rules also.
We will not say anything. We will ask the university
Yes.
authorities. Mr. Fukan will take care.
She may herself recuse herself. I don't know.
No, no, Mr. Fukan will take care of that.
Most of them.
Oh, it will be.
On the last occasion, my lord.
Yes. Oh, that matter.
Selling the appointment of the respondent number 9.
Yes. Anything, Mr.
Well, I'm not on the merit of the case.
No.
Logic. But here the issue which Lordship has not indicated here, not ultimately the situation that I have taken up with the authority, and what I would like to submit, my lord, in view of the decision of the Devabrata Tewari's case, my lord, State of West Bengal versus Devabrata Tewari's case, the position in detail has been clarified, my lord. Now it is well clarified. So, my lord, the authorities they have my lord, ultimately the applications which are pending for long years, my lord, long pending applications are being considered at a later stage, my lord. That is what's going on. Now, my lord, they have ultimately in view of this decision and along with the other circumstances, my lord, going by the object of the compulsory appointment. So they have to my lord, take up the matter at their my lord, end. And ultimately, my lord, whatever applications, if those are not cannot be considered for 19 years or 15 years, 10 years, 12 years, but they have to ultimately following this ratio, my lord, stop them. And but what I find here, my lord, I have taken up the issue with the authorities. It is in their mind, my lord, some I'm not in a position to verify all the facts, my lord, under what circumstances these are being considered. I have asked them, but they said that it is a huge task because each and every case has to be seen individually. One case, it was pending from 2004 or 2009. Why? Under what circumstances it was not placed before the DLC or SLC earlier? That has to be gone into in each and every case. Facts and circumstances are different. It is with the authorities because of fault of the authority, because of fault of the petitioner, some informations are not available, or DLC was held, it was placed, but the vacancy positions are not clear. So many factors are there. But in any case, now going by the object that after 10, 12 years, 17 years, the object no longer subsists. That is the basic consideration, and that has to be taken care of by the authority, and they're just going to implement that.
They're going to do something.
Yes.
They will have to do it after giving notices. Due notices. We'll give you some time. Don't worry.
True. The office memorandum which they have prepared, it is 1/6/2015. After 1/4/2017,
It's not there.
There is no, there is,
No,
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 there
it's
is
not
no, not there. Only the difficulty we are facing with the pending application.
When was the death of the father?
All of 99, my lord.
99. And the appointment made, he is 22.
21, directly recommended and
22 appointed.
appointed, my lord, page 56.
So, Mr. Nath,
Ma-
what do you propose? You want
Ma-
some time, more
I-
time?
I am allowed, yes, my lord, we need some more time to, but because the present position, in view of the present position and the decision of the Honorable Apex Court and.
We'll give you
and that
time till
position.
3rd of
Lordship,
June.
my lord. My lord,
I'm keeping it partner. We'll give you time till 3rd of June.
Lordship. My lord, can I just pray just little bit because third, fourth, these are election results, they, my lord.
Results? Oh. When?
But just next week on 10th, my lord.
10th, no problem.
Lordship.
List this matter. Mr. D. Nath, learned senior government advocate, Assam, has made his submissions in the matter. And upon making such submission, Mr. Nath has requested this court to adjourn the matter today so as to enable him to get further
Noted.
instructions from the respondent authorities as to the nature in which cases of claims for appointment on compassionate grounds are being considered after lapse of long periods of time. So prayer accepted. List this matter again on 10/6/2024 for further hearing.
My lord.
My lord, all right.
I get 24 and 27.
Yes.
May I please, your lordship?
That is lordship.
Your lordship, here we need to file our affidavit. We'll be filing it tomorrow, your lordship. Already affidavit has sent for vetting.
I don't bring it. 2021 matter. 21 matter.
21.
Service complete. 5 and 6. Who is appearing for 5 and 6? Who is appearing for 5 and 6? Respond number 5 and 6. Why are you standing there? Yes, what is your prayer?
Lordship, my senior thesis, he is not keeping well, lordship.
On the prayer of the 11 parties to the proceeding, list this matter again after 2 weeks on a date to be fixed by the registry. The respondents, before the next date of listing, must invariably bring on record their respective stands by way of filing their affidavits in the matter. All are principal selection matters.
Lordship, regarding headmaster of Nagabandha High School, 24 and 25, I am appearing.
26 and 27, what is that?
PTCs.
I'm on behalf of 27. Respondent. Okay, 28.
Obliged.
Yes, 28th lordship, we have issued a sanction letter for creation of the supernumerary post lordship. I kindly read enough.
What is the date of that communication, Mr.
That was lordship, that was I am telling. It is a printing mistake on last occasion lordship. It should have been 17/4/24 and instead it was written as 17/4/23. And I have already got the sanction order. But I can check in video. Now the director will send a salary proposal that will, after getting that proposal, it will be sanctioned that area salary, they benefit. Now he has already been promoted for that respective duration of it.
Anything more left?
Well,
We can close it. Mr. SMT Sasti on instructions has submitted, Mr. SMT Sasti has placed before this court a communication dated 29/4/2024 in continuation to the communication already placed on record on 15/3, dated 15/3/2024, wherein, no, sorry, not that.
One is regarding clarification and lordship regarding the date, and other one is a sanction letter.
The sanction letter was before me.
The sanction letter of today only, 2/5/20 of 2/5/2024 lordship.
Okay, Mr. So, Mr. SMT Sasti, learned counsel appearing for the respondent, has produced before me, as punished before this court, a communication dated 2/5/2024, issued by the Joint Secretary to the Government of Assam, Department of School Education, to the Accountant General Assam, wherein it has been stated that the Governor of Assam has granted the sanction for creation of a supernumerary post of Assistant Director, bracketed Planning and Coordination in the Elementary Education Department for the period with effect from 28/2003 to 21/2006 in respect of the petitioner hearing. Also, it is contended that the directions as passed by this court for promotion of the petitioner against the said post is now concluded, and the areas of pay that would now accrue to the petitioner would be so released to him shortly. Will do?
Yes.
Shortly.
Yes.
Also, Mr.
D.
Your
Bora.
name?
D. Bora.
D. Bora, learned counsel for the petitioner submits that the steps as taken by the petitioner here, by the respondents hearing, is in satisfaction of the directions passed by this court, and accordingly, he also submits that the contempt petition need not be pursued any further. Also, accordingly, in view of the communication dated 2/5/2024, the present contempt petition stands closed. A copy of the communication dated 2/5/2024 is kept on record and marked as A for the purpose of identification.
Applies. Not applies.
Mr. Chestry, is Chestry any information?
That is what I'm looking at, no lawsuits.
Don't worry, we'll have it after some
Yes,
time.
after some time.
2 o'clock we'll have it.
2 o'clock.
If you, any problem,
Some other day, or if.
some other day.
Yes, some other day. They also not present.
Mr. SMT Sasti, none appears for the petitioner. Mr. SMT Sasti, learned counsel for the respondents have submitted that the instructions as required to be furnished by the respondent authorities have not been received by him. So accordingly, he prays that the matter be taken up after 2 weeks.
Yes.
Also, prayer accepted, list this matter after 2 weeks on a date to be fixed by the registry. Mr. Sharma.
Yes.
What have you done? Nobody is here. You have asked them not to come in the court.
They have not come. Your lordship asked me about whether I.
What will I do hearing you if they are not there? Can you get hold? Who was there?
Yes, my lord, I'm appealing for respondent number 4.
Who is there for the organization, BRPN? Mr. Decca was, Madam Decca was here yesterday.
You have the decisions, Mr. Sharma.
Yes, I have a
Just-
short one, not on exactly that point, but in nature of the case, it is the same, my lord, here. The Supreme Court.
Mr. You have a license under 7? or
Yes,
12?
my lord,
Labor Regulation and Abolition Act to such. SME. Contract Labor Regulation and Abolition Act, 1970.
they have their license, my lord. They have filed affidavit, they have license to engage in labor.
I have filed your receipt.
Yeah, my lord, in practice, same, my lord.
Come on. You have not alleged any unfair labor practice here.
My lord.
You have not alleged unfair labor practice.
Unfair, because I have been.
You have not alleged unfair labor practice has a separate
That is
connotation.
the nature of the case. Nature of the case says that it is the unfair labor practice, because instead of this.
Your
instead-
case is basically,
No,
Mr. Sharma, that we have been working perennial nature of job. So kindly give me. You have not disputed. Kindly, you have not disputed
Yes.
that the respondent number 4 is authorized to carry out a contract work, labor work, in terms of the Contract Labor Regulation and Abolition Act 1970. You have also not brought on record anything to show that the institution, that the, what do you call that, the BRPL, does not have a license to employ contract labor. So 7 and 12 satisfied. So it boils down to section 10
Yes.
of the Contract Labor Regulation and Abolition Act. Now, under 10, you have not moved. There is no order under 10. In that view of the matter, your employer from him, can it be said to have shifted to BRPL?
They could have been engaged by the BIPL, but instead of engaging by themselves, they have the petitioner has
Can't
been
help it.
engaged to the contractor.
Can't help it. Can't help it. That is permissible.
Because the similarly situated.
That is
employee-
permissible, Mr. Sharma. That is not impermissible. That is permissible. There are
Similar-
decisions of our court also. Okay, I'll give you.
I may be allowed to analyze the thing.
You analyze it. I'll give you a judgment.
Your lordship kind of see.
98 to GLT 67.
There are 30.
How many Getu?
Sorry.
98 to GLT
There are
67.
There are 10 of the decision.
Asin. 1998 to GLT, page 67. Kindly examine this judgment.
Here, my lord, para 10 of the decision.
There is one more thing you will have to answer, Mr.
Finding of.
Sharma. We'll come to that. You will have to answer one more thing. You come, there is an affidavit filed by the Regional Labor Commissioner. Have you seen that?
Yes.
Huh?
Regional Labor Commission.
Regional Labor Commissioner has filed an affidavit here.
Labor officer, they have not filed the affidavit.
Yes, there is an affidavit dated 16/6/2017.
16/6/2017.
It is by one Mr. Bishop Bhushan Prusti. Have you got it?
Yes. It is under para 6.
Para 6.
Para 6. As regarding statement made in paragraph 3 of the petition, your deponent beg to state that so far the paragraph is concerned, respondent number 2 has a role to play. However, it may be stated that the matter of recognition of the service of contract workmen does not come under the ambit of the unfair labor practice, since both are two different things.
And you go further.
But here the.
You go further.
My
7.
para-
And Mr.
Other things.
Mr. Sharma, kindly go through that 1998 to GLT 67. 1998 to GLT 67. Similar situation, I don't have the book. Similar situation, this court had held that this reference is not maintained.
They have mentioned it in your package to yours. So much.
1998 to GLT 67. You have that decision.
Nineteen ninety-two GLT.
67.
The Guwahati High Court has laid down that in the absence of relationship of employer and the employee, the dispute cannot be brought within the fold of the definition of industrial tribunal. Because here is no direct employer and employee, but indirectly payment has been made by the BRPL through the contractor. So there is the indirect.
That is the only submission you have.
That is the contract.
Okay, fine. Anything more, Mr. Sharma?
Anything more?
Anything more?
My submission, my lord, it is purely unfair labor practice. The works are paying.
Okay, show me the paragraphs where you have referred to that unfair labor practice.
Unfair the nature of the work.
No. The allegation that it is an unfair labor practice.
Similarly situated person getting the more salary, but they are getting a very small salary because they have been engaged through the contractor. That is the works are paying in nature.
Are you being paid the minimum wages that is stipulated by the government? Are you being paid the minimum wages that is stipulated by the government?
And here, my lord, the thing should come out when the matter go to the tribunal. The whole thing should
I'm
come out.
not convinced. You will have to convince me.
Your lordship, can you see that?
You will have to convince me. Mr. Sharma has practical experience about industrial disputes.
Yes.
I want to learn. That is why I'm behind you.
Your lordship, can you see the para 10 of the decision? Para 10 last.
Of which that decision.
Thus, the finding of the unfair labor practice of the engaging person on contract basis. Engaging person on contract basis over a long period of time. They have been engaged since 1981, my lord. Over a long period of time was held to be an aspect of which could be inquired into by the labor court, my lord. So it is they have been engaged since 1981. Works are paid in nature. It is permanent. It is the work of the what is called refinery, my lord. Instead of engaging them directly, they have been engaged for the labor by paying a small amount of money. Because the similarly situated person, engineer, fitter, lineman, who are permanently engaged by the refinery, they have got a sufficient income, my lord, but they have been exploited. That is unfair labor practice, my lord. So when the matter come into tribunal, if the central government, if the labor authority refer the matter to the appropriate government will send it to the tribunal after exemption, then the things will come out, my lord. But instead of referring, they have not held the consolation. The labor authority and respond number 2 and 3 has not held any consolation, which is requirement of section 12 of the Industrial Dispute Act.
Here, Mr. Sharma, were they under contractor or they were directly appointed as contract employees by the employer? Okay, we'll consider. But where is the main respondent?
Yes, respondent number 3.
No, you are preparing for whom?
Yes, I am for the respondent number. Respondent number 1, madam.
You are for respondent number 1
Yes,
only.
madam.
2 and 3 are not here.
Yes, my lord.
Mr. Sharma, respondent number 2 and 3 are not here. 2 and 3.
20.
Indian Oil.
That is labor.
No, Indian Oil.
Engaged.
Sorry, 3. Respondent number 3, Indian Oil.
Three is India. Ken Chaudhary. Ken Chaudhary.
He's not here, wait.
Ken Chaudhary, his junior was here on the day.
That day,
That is my lord. She Burua, Ken Chaudhary.
No, we have got it. We have heard it, Mr. Sharma.
Yes, ma'am.
So we'll fix it on a different date. We'll hear if something is there, we'll do. When, Mr. Sharma, when should we get the matter listed?
My summary, it is clearly unfair labor practice.
Fine, we'll just hear them also.
All right, under that we fix next week.
When?
Next week, get it.
This court may not be here, so you will may have to re-argue. That's a different thing. We will list it on 28th.
28.
I'll not be here, maybe. I don't know when my position, what it is.
It will go to other court.
Maybe.
Then can you keep it part hard, my lord? Because the major part is hard.
If I'm here, I'll take it. Don't worry.
We are hard for 2 days.
No, I'll take it. It's an interesting question. I have learned something from Mr. Sharma.
It will be better if this keep part hard, my lord, because.
For further hearing, really.
I know item number 16 has fixed at 2 p.m. my lord. Item number 16, my lord. It has been fixed at 2 p.m. my lord. There is a division bench in court number 1 at 2, my lord.
We fixed it at 2 p.m. I suppose.
Yes, my lord. At 2 p.m. there is a division bench in
You
court.
tell Mr.
I'll
Shah,
tell my lord, that will take it.
on the prayer of Miss A. Diane, list CGC, list those matters again after 10 days on a date to be fixed by the registrar. You just inform Mr. Shah. He'll, I think, consent.
Yes.
All right.